What about the other side?
Other side, I have taken consent from the counsel for the private respondent.
Learned
Informant.
counsel, okay. Learned counsel, Mr. A. Sama, with the consent of the other side, has prayed for adjournment, list the matter on. When do you want?
24/6, if not in.
Proceeds.
Oblige.
May I plead your lordship regarding item number 26, lordship.
Mm.
You kindly take up the matter some other day, lordship. If possible, on 26th of May, June, lordship. I have taken consent of other side.
Huh? Last week, I think before vacation, last 2 weeks won't be possible.
And after vacation, lordship kindly fix it.
After vacation.
Yes.
Learned counsel, Ms. P. Bhattacharya, no? With the consent of the other side,
Yes.
has prayed for adjournment, list the matter of vacation officer.
Oblige.
I beg to mention my two matters, my lord. I have filed IA, my lord. 5 years conviction, my lord. Will state on 16th of June, my lord.
Put to bench. Huh? I'm so sorry, you'll have to go, you'll have to be
Malad,
before
malad.
court number 3, but time's up
Malad.
to date, maybe
Not
tomorrow.
at all.
My lord, I beg to mention item number 34 and 35. Kindly taken up at 2, my.
We have two hearing, long pending hearings, continuously carrying on.
My lord,
In the afternoon, nothing will be possible
so
today.
my lord, that it may be updated, my lord, before my lord break, my lord. Because it lasts 2 to 4 days, my lord.
Updated,
This is not possible, my lord, because all these methods.
upgraded.
These are.
No, upgraded not possible today, not
That is
possible,
my-
because we have already fixed some matters for hearing. Tomorrow?
My lord, these matter have been earlier listed on 2nd, then 4th, then 6th, and today it is.
তো কালে হবো নি?
Next week, anything.
Now, my lord, then as is.
কালি হিয়ারিং ডে হয় আজি হিয়ারিং ডে
No, my
কালে
lord,
হবো
then,
নি tomorrow
no, then as usual it will come, my. On it tomorrow.
Hey, please, your lordship. I beg to mention, hearing matter item number 22.
Hmm.
On the last occasion, we prayed for a paper book, but ultimately we have given it for translation.
Hmm.
And parties are supposed to engage a senior advocate.
Hmm.
So 2 weeks accommodation, your lordship.
Which one?
22. Old pending. 2012.
Learned counsel Ms. S. Das Gupta has prayed for adjournment as they are preparing translated
copies,
copies of the depositions which are illegible.
Yes.
List the matter positively for hearing on after vacation then,
Yes, sir. Much obliged.
as this is a long pending case.
Much obliged. Lord.
With the consent of the petitioner, my lord, I beg to mention item number 27, my lord.
Hmm.
May I pray, my lord, this matter may come after the vacation. I've taken consent of the petitioner, my lord.
Learned counsel Mr. S. Khan with the consent of the other side has prayed for adjournment, list the matter after vacation.
After vacation,
List the matter after vacation,
much obliged.
May I please your lordship, I beg to mention for listing, motion matter, transfer petition, so matter may be come up, very urgent matter, so matter may be come up tomorrow. Oblige.
May I please your lordship? I beg to mention item number 25 to resist, my lord. The matter will be listed after, my lord, vacation.
25.
25, my lord. Hearing matter, my lord.
Learned counsel Mr.
R. Hazarika, my lord.
R. Hazarika with the
Represent-
consent of the other side
I have informed the people, my lord.
has prayed for adjournment, list the matter on after vacation.
My lord. People.
May I please your lordship, I beg to mention for item number 21, lordship.
Hmm.
The English counsel is not well. Kindly this matter may be taken on Monday, lordship. It is a part heard matter, lordship.
Item number.
21.
Learned counsel Miss M. Bora,
Yes, lordship.
Vice Learned counsel Mrs. B. Gogoi
Yes.
has prayed for adjournment. List the matter 21.
Monday, lordship.
এইটো নেকি? Mrs. B গগৈ আছিল নেকি? দি থোৱা আছিলো. I'll list it as part and matter or
Yes,
I'll release it.
Lordship.
I'll list it as part and matter or shall I release it?
No, lordship, part heard matter.
Or list the matters. List the matter as part and matter. Date the video. When before
Lordship,
vacation?
Monday, lordship.
On Monday.
Yes.
At 2 p.m.
Yes, lord.
May I please, your lordship. Lordship, I beg to mention item number 39. We have taken the supplementary list here. We have taken the consent from the other side. I pay
Hmm.
for accommodation for today also. 39 supplementary list.
Learned Coun-
Lordship, with regard to that, a short date may be fixed regarding 26th of June, Lordship, a date convenient
26th
date.
of June.
Will is order column, Lordship.
Fine, no? Learned Counsel, Mr.
S.A. Bhakhtiar.
Lordship, I beg to interrupt your lordship. We have given the consent on the basis that tomorrow the execution case is fixed for hearing in the lower court. Your Lordship. Lordship, we have given the consent that they would take an adjournment tomorrow in the lower court also.
Lordship,
Otherwise, would have pursued the.
it can be
Yeah,
proceed
this
for.
condition I cannot impose here. It will be difficult, no? This is pertaining to lower court. I cannot impose this condition here.
There is a stage of hearing on a petition, Lordship. We have filed a petition. Lordship, it can be,
He'll
it
give
can
you
be deferred.
adjournment. He'll keep his word. He is a
It can be
gentleman.
deferred, Lordship. It can be,
Don't worry.
we pay for accommodation for that.
Down.
No.
For that, a day, the 26th of June will be a convenient date for both of us.
Mr. S. Bhakhtiar.
S.A. Bhakhtiar.
S. A. Bhakhtiar on behalf of
An alarm for respondent 1.
L. Anam for respondent number 1 with the consent of the other side has paid for adjournment. List the matter on
26th of June.
26th June.
Much obliged.
Keep your-
Item 1.
My lord, this matter may be passed over for the day, my lord.
Okay. Learned Counsel, Mr. M. Ali
My lord.
has paid for adjournment. Leaves the matter on after 1 week or after vacation?
My lord, no, after 1 week.
After 1 week.
Obliged.
Move is my lord.
Hmm.
I have filed a revision petition against the order dated my lord. 11/4/2025 passed by the Principal Judge Family Court regarding interim maintenance, my lord. Actually, real fact is that my lord petitioner and opposite party, not a husband and wife. As per the annexure 1, my lord. Annexure 1 copy of the main petition, my lord, that clearly mentioned that she is the wife of another man, lord. And the children is in her first husband, my lord. Thereafter, subsequently, he married the petition along with petitioner, my lord. Opposite party state in her petition, my lord. In para annexure 1, my lord, page 10. Page 10 is the main petition, my lord, in
Can you
family
bond
court,
with-
my lord. And that clearly
Is the, my lord, absconding accused, my lord,
Mm.
shown in the charge sheet, my lord. So kindly have a look at page, my lord, 9, the FIR, my lord. Page 9, my lord. May I read, my lord?
Yes.
Yes. Say, there as many as, my lord, in the FIR, my lord, accused person's name is, my lord, Tosir Ali, my lord, a son of Mohar Ali Sheikh, resident of so and so, son. I have the honor to state that the Ejahargari is a permanent resident of the above noted address on 19/1/2025 at about 9:30 p.m. The accused persons attempted to murder the brother of the Ejahargari Brindavan Rai by hitting on his head by sharp weapon, consequent upon which he was injured grievously and blood flows from his head in large scale, and thereafter he was shifted to Bashugao MPH hospital, where taken preliminary treatment, then sent to Lower Assam Hospital, Bongaigaon, Assam, for better treatment, and till then he is kept in ICU of the hospital. After committing the incident, the accused persons fled from the place of occurrence. The accused persons also tried to murder the victim by dumper by crashing the four-wheeler of the victim where he was present. And my lord, in this case, actually there was, my lord, there was some, my lord, altercation, and there was a collision in between the dumper vehicle of the other accused Tosir Ali, not the present petitioner, my lord, and with another four-wheeler vehicle, my lord. Anyway, my lord, after completion of, my lord, investigation, my lord, police has submitted charge sheet, my lord, in this case. My lord, in the charge sheet, my lord, kindly have a look at page, my lord, 15. Page 15, my lord. In the charge sheet, my lord, charge sheet have been submitted against, my lord, 3 numbers of accused persons. But out of 3, my lord, the present petitioner's name has been inserted as absconding accused, my lord.
Hmm.
That is, my lord, page 21, kindly. Page 21, my lord. Clause number 10, my lord. The accused,
He's the father of the main accused.
my lord.
Morally, is he the father of the main accused?
No, no, my lord. This is,
Here
this
talk-
Mohar Ali is different, my lord.
Okay, okay.
This is not the father of the main accused, my lord. This Mohar Ali is different from different village, my lord, also.
Okay, okay.
Says, after completion of, my lord, investigation, against 3 persons, charge sheet have been submitted, my lord. In the charge sheet, my lord, charge sheet has been submitted under section 109, 118, clause 2.
1090, sir.
My
Attempt to-
lord,
One-
my lord, present
attempt to
position
murder.
is very clear. The present position petitioner is shown as.
Yes, my lord. But
You
So,
appear, will.
yes, my lord. That's why, my lord, I am interested to appear, my lord, and
Yeah, you
cooperate.
appear.
And other
Yeah,
accused
yeah,
persons, yes, my
till
lord.
that date, my lord.
We'll keep that,
Yeah.
NBW.
My lord,
What has been issued against you?
In this regard, my lord, I would,
Summons.
my lord, summons, yes, my lord. I have issued, received summon, my lord. And
Summons should, my
on
lord,
next,
be-
my lord, tomorrow is the date fixed, my lord. Already one date has gone, my lord, and we have appeared, I have appeared through my engaged counsel, my lord. And tomorrow is second date, my lord. Thus, I am interested to appear and face the trial, my lord. And in this regard, this Honorable High Court has passed so many orders, my lord. I have annexed those orders, my lord.
Anticipatory bail cannot be granted in this petition.
But my lord,
This petition.
but a similar situation, my lord.
No, no.
Similarly situated, my lord. Kindly have a look at page, my lord.
I cannot understand how in the
Uh,
petition under section 528, somebody can grant you anticipatory bail.
My lord, kindly have a look at page 31, my lord. Page 31.
This is criminal petition, not
Criminal-
also, my lord, bail.
My lord, in criminal petition, my lord, yes, kindly have a look.
Petition, my lord, how bail can be granted? my lord?
Page 31, my lord. Annexure 5. Page
I have seen
31.
these orders. I have seen these orders.
Yes, yes, sir.
Never granted
But,
anticipatory bail in under section 528. Never.
and there are, my lord,
82, never.
another order, my lord, in page 33, I have annexed.
Your lordship is not
Well,
governed by.
This
my lord.
all cases are, my lord, sessions tribal, my lord. But now, my lord, now case is pending before the learned judicial magistrate first class, my lord. That's why if he will appear, my lord,
Okay, then what, you can,
then I may be allowed to go on bail, my lord. That's,
you can
I will,
file a petition. See, this order is anticipatory bail application.
uh,
Page 38.
page,
Page 38 is not a petition under section 482.
page 38.
This is
That is AV, my lord.
Those cases,
That
my lord,
is-
NBW issued, my lord, here only summons issued.
Summons has been issued.
Some issued, my lord, but
And anticipatory bail is issued only when warrant
Those
is issued.
petitions were filed against that NBW.
Anticipatory bail is granted only when warrant is issued. So here,
my lord, I'm,
you have a relief. You
Yeah.
don't press this petition. You file a prayer for anticipatory bail. If you are not willing to surrender and to be forwarded to custody, you file a prayer for anticipatory bail. This, otherwise you can wait for another date so that it may go to other defense.
well, my apprehension
only
is
my
that,
lord
my lord,
is
if
right.
I am interested to appear and cooperate with the trial proceeding, my lord.
No.
But
No.
what happened in this case, that I am
No.
apprehending, my lord, that if I will appear,
Forward you to the trial court, and I would have kept the NBW and evidence, but here now you are on
Yeah,
summons.
only till that, till
then
that
I would like to
Not press.
withdraw matter, my lord. Withdraw this case,
You
my
want
lord.
to withdraw?
Yes, yes.
You'll file
That's
prayer for
liberty
anticipatory
to
bail.
file, my lord. I will file the AV, my lord.
All
It's,
right.
after.
Learned counsel, Mr. S. Ahmed. You are S. Ahmed?
My lord, sorry,
S.
my lord.
Ahmed. S. Ahmed.
Yes, Ahmed, my lord.
Learned counsel, Mr. S. Ahmed has prayed for withdrawal of the petition. Third learned Mr. P. Bothagur, learned HLPP Assam, who has raised no objection. Petition is dismissed on withdrawal with a liberty to file fresh
Petition.
petitions.
Either AV or either.
Anything,
I said,
petition
obliged.
will imply anything.
My lord, my lord. Obliged.
May please, my lord, application file for quashing the complaint case, my lord. Annexure 1, my lord, page 7, the complaint case, my lord.
Mm.
Whole case is, my lord, allegation is land, my lord. So it is not a criminal case, my lord. It is a civil nature case. All right, and it's see, my lord, page 2, page
This is a
8,
complaint case, no?
complaint case, my lord. But all the complaint case fact, my lord, all the petition that is regarding the land, my lord. That is,
Where is your complaint?
I am the husband and the complainant is the wife.
Oh.
Husband and wife, my lord.
Where to complain?
Lordship, the this notice may be issued, Lordship, the husband and wife, Lordship, and prior to this, they get married, Lordship, and
Lordship may kindly see paragraph number 2. It was for repairing of a Silchar Janatepur road under State Disasters Relief Fund for repairing a stretch of road measuring 1.66 kilometer. And for the said purpose, a contract agreement dated 9/10/2013 was agreed number so and so for a sum of rupees 43,02,932 was executed. Then I participated in the work. I will show 2-3 things to your lordship, will understand. First, lordship may kindly see annexure number 2, page number 22, lordship. Lordship, these are the photographs of the road before the work was done. Lordship may kindly see. These photographs were taken at a time of the page number 22, annexure number 2, lordship may kindly see.
Okay.
Then lordship may kindly see page number 23. The second photograph is after the work. Page number 24, before the work, and then it is after the work. And so on, we have given all the photographs and showing that the work has been done in a successfully manner. Then lordship may kindly come to annexure number 1, page number 21. This is very important. This is the work completion certificate. Certified that the work has been physically verified by me and 100% completed by the aforesaid contractor in all respect as per the specification, drawing and the tender agreements. So this letter, lordship may kindly say this completion certificate was given to me in 2013-14 itself. Then what happened? When I started requesting for giving me the money, what the DC did, DC after a period of 2 years, DC goes for inspection. What you will see, annexure 3, page number 26, is the FIR that has been lodged.
Page number?
Page number 26, annexure number 3, lordship. This annexure, this FIR that has been lodged by additional deputy commissioner Silchar. Then lordship will see that this is 2016 an FIR. Then it is filed with the wrong jurisdiction, lordship, Silchar PS. Then what happened?
This road was under which jurisdiction?
This road was in Silchar only, but it was the jurisdiction was different. I am coming to that, lordship. Page 28, lordship will see that they are saying that the work has commenced on 9 October 2013 and work was not found to be and during physical verification it was found that the gross misutilization of the government fund. This is absolutely contrary to what the engineer finds. After 2 years, it's a very busy road, lordship. Vehicles are plying regularly and lordship knows.
I know the roads very well.
Yes, lordship knows the condition of Silchar.
I know very well.
Because of the rainy seasons and all, this things happen. So 2 years, after 2 years, definitely the condition of the road will not be the same as it was earlier in the 2 years. Then what happened, lordship, what they did, 2018, they registered another FIR. Absolute violation of TT Anthony's judgment.
Okay.
Annexure number 4, page number 31. 2018, lordship will see. Now they come to, this is what is the PS, Barthola PS, 2018. Then they investigate same FIR. Same FIR in verbatim, absolutely in verbatim, nothing to do with anything. We can say that the earlier FIR has been transferred. That can be said. It could have been renumbered. There was no requirement of a registration of a fresh FIR. Then what they did in the second FIR, after completion of the investigation,
Page number 31, second FIR.
Second FIR, lordship will find is page number 31, annexure number 4. Then after that, what they does, they continue with the
But the
investigation.
FIR is not in this, this is the
Yes,
auditor
the
format.
earlier FIR,
Ah,
they have treated it as the FIR itself.
okay, okay.
They have simply renumbered. But what they have done, they under 154 format, they have re-registered it, which they should not have done it. They should simply have given a number, that's all. The question of re-registering that does not require at all, because what I will show you, Lordship will kindly see, here the sections are 120B, 420, 406, 409 IPC. Earlier that was the same section under which it has been registered. It was also 120B, 420, 406, 409 IPC. Now, Lordship will kindly come. After all this, after a period of about 9 years, they now files the charge sheet. Now, Lordship will kindly see, this is the impugned charge sheet in Annexure 6, page 37.
Hmm.
Now, I will take your Lordship kindly to what is there in 173.
170?
173, because it is
Okay.
earlier, it is as per CRPC. Now, 173, Lordship, is corresponding to language as almost the same thing.
Hmm.
Corresponding to BNSS again, ठीक है sir. 73 will be.
It is submitted under BNSS or one?
No. It is submitted
IPC.
under CRPC itself, IPC.
Okay.
I am not on that, Lordship.
Okay.
Lordship may kindly come,
Ah.
because 173 wordings of 173 and 193 wordings are same. There is no change. So since I am having this book, I borrowed from my brother, I am reading from this book only. 193, Lordship may kindly see report of the police officer on completion of investigation. What requires to be there?
Okay.
93. I have find out 193, Lordship. I'll just read it out.
Yes.
Every investigation under this chapter shall be completed without unnecessary delay. The investigation in relation to any offense under so and so, this is not required, number 2. Lordship may kindly come to number 3. As soon as the investigation is complete, the officer in charge of the police station forward include through electronic communication magistrate empowered so and so, name of the parties, nature of information, name of the person who appears to be acquainted with the circumstance, whether any offense appears to have been committed, and if so, by whom. Now, this is what is the thing that is required to be there. Lordship will kindly see here, there is nothing. What they write, during investigation, prima facie case under so and so is made out. What is this?
Second FIR?
No.
Or charge sheet?
Charge sheet. So they have to write out during investigation what they have got. Because your Lordship will see in 173, what does it says? The nature of information. So the nature of information has to be there. Then your Lordship will see whether the accused, this is not important. I am on here only, Lordship.
All right.
Yes, whether any offense appeared to have been committed, and if so, by whom. So it is absolutely not there. Absolutely
Where
not
is the
there.
charge sheet?
This is the charge sheet, Lordship. This is the impugned charge sheet.
Page?
Page 38, Lordship. During investigation, a prima facie case is made out. How the learned magistrate will apply the learned magistrate's mind for the purpose of taking cognizance. Now, the Lordship will see, Lordship is well aware of the Pepsi Foods judgment.
Hmm.
Now, I will take your Lordship to the, thank you, Supriya. I will take your Lordship to the cognizance that has been taken. Because court is helpless. This sort of charge sheet, court is helpless. In other words, what the court does, upon such perusal, I am of considered opinion that there is sufficient ground for proceeding against the accused person, namely so and so, so and so, so and so. Pepsi Foods judgment says, Lordship, that taking cognizance is not a mere formality. Court has to specifically write down, note down as to where and what offense has been committed. and why the court has come to a opinion.
Mm.
That is very clear. So, Lordship, I have challenged this charge sheet, charge sheet as well as the order of taking cognizance, and I would pray, Lordship, that after a period of 15 years, I have borrowed the money, I have made the work, I have executed everything.
And money is not paid.
Money has not been paid to me.
We'll stay.
No, Your Lordship, I'd like to point out,
No, no.
let him complete, I will point out.
No, I have completed.
Yes, then I will have you point out, Your Lordship may kindly come to the FIR, page 28, and at the same time, I will point out, other also some.
So, place 20, I am also
Because my
pointing out,
learned
before
friend
my
has
brother
pointed out
says
that
something.
There are two affairs, I will point.
Before my brother says regarding page 28, I would like to say 2 and 3, no back topping is seen in the entire stretch of the road. Compared to the photographs of the road before or after the execution of the work, this is completely different and no similar to the practical. Moreover, no date is mentioned in the photograph. Now, Lordship, after 2 years, Lordship, kindly see when 16, and it was in 2013 when my work has been done. Can it be the same road? My brother want to point out to that one. Can it be the same road? How it can be the same road?
Impossible for Karimganj.
Impossible, Lordship.
Impossible for
My lord.
Silchar.
Yes.
Within two,
My lord,
3
now
months, the
this
road
matter
gets
is-
damaged
My lord,
because of the type of work.
Yes,
they are doing.
type of the water,
Contractors.
the floods,
Type of work
flood,
contractors are doing.
flying roads, and this is the most
But
busiest.
I think he has sufficient ground.
No,
for
I will
staying.
just point out, to Your Lordship,
Why? Why?
Now, today matter is listed for motion, In this case, investigation completed, search sheet submitted.
Yes, yes.
And now in this criminal petition, my learned friend trying to show some of the photographs. Whether at this stage, Your Lordship can go and see on the
Photographs
basis of,
submitted with an
uh,
affidavit.
Yes.
but those photographs were, or those, thereafter investigation completed and search sheet submitted.
But you see,
And matter relates to, embezzle of.
the completion certificate was given 100%.
Then Your Lordship, that I will point out, Your Lordship, page 21, who has given the completion certificate? Executive engineer. He is an accused. Your Lordship may.
He's
kindly
an
come-
accused.
He's an
Yes,
accused.
I would like to.
3% are
Yes,
accused.
with reference to the subject cited,
3%
I am
right.
to inform you that the Deputy Commissioner Kasar, along with the Executive Engineer PW Rural Road Silchar DPO and Kasar concerned Section Officer Abhijit Pal so visited and physically verified the Silchar roads as for the year so. And the following, so these are the anomalies, my lord. At last, my lord, the sanction amount of the scheme is rupees, 43.0. These are public money, my lord.
But my brother is missing one thing. My brother is missing one thing, very important thing. Why the IO has not mentioned all these things in the charge sheet? Who precluded him? 15 years he has investigated. Who has precluded him from mentioning the photographs were not dated?
Well, after he has
Photographs-
completed-
No, brother, please. Only for the purpose of objecting, please don't object. You
You have
understand?
completed your submission. Let me submit. I am not objecting. I am just pointing out.
I'm not
So let
saying,
me allow.
I'm not saying
I
anything
have
to
not
you.
said.
You see 173 vis-a-vis you see your charge sheet.
Oh.
See vis-a-vis 173 and then you say your charge sheet.
Let him complete, my lord. I will
No,
just,
it's okay. Please carry
I'm
on.
just pointing out.
Yeah, this is the FIR, no? So he is
my
one of the.
Yes,
accused.
3
Your
persons are accused. 3 persons are accused, Lordship. But what is my role, Lordship?
That executive engineer,
Executive engineer, chief engineer who was in charge,
Ah.
and I myself. So what is my role, Lordship?
you are the contractor.
I am the contractor. I have come-
Engineer who issued the
Completion
completion
certificate.
certificate is also an accused.
He is also an accused. Now, Lordship, I have come qua the petitioner. I have not come for all of them. I don't know. Let them do whatever they want to do. I have come for qua the petitioner. Absolutely qua the petitioner.
Oh.
Whether
Yes,
something
yes, yes. Please continue. Please.
So complete, So, my lord, my duty is just to point out. Ultimately, your lordship, it is the discretion of your lordship
Yes, yes,
grant
it's
or my lord
okay.
not granting stay, my lord. So while I am appearing on behalf of the state, it is my duty to point out whatever
Yes,
material
absolutely. We
I have
appreciate
also, my lord. I am only pointing out because this matter relates to my embezzlement of public money. my lord.
Yes.
Here from the FIR, because at this stage the matter is still listed for motion, and my friend, is against quashing of the FIR and search sheet. And my lord, in this case, my lord, after completion of the investigation, my lord, after search sheet submitted, that means, my lord, finding sufficient, at least, my lord, at this stage, that there are sufficient material against the accused, and for which after investigation completed and on the basis of which, my lord, now court has taken cognizance. Now court has only taken cognizance. Charge not yet framed. My learned friend has time to place all these materials at the time of framing charge before the trial court. And now by placing all these photographs of the road, my lord, how I can, my lord, from these photographs, my lord, only because he has submitted affidavit, my lord, that this is the photograph of that particular road. Maybe this is a photograph of, my lord, in front of our high court, my lord. How can I say that this is the photograph of
Brother,
that particular
brother,
road?
no, no,
he
no,
has
no, no, no,
constructed?
no, 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 no.
So,
I will
so
not
let me
agree to
submit.
this. I will not allow you to submit
So,
because you are
I am
misleading the
pointing
court.
out because those
Just-
photographs.
Let him complete.
So I am just
Lordship,
quoting. So those photographs now by annexing in this petition, because in this case, my lord, after completion of investigation, police has submitted a, my lord, search sheet. So let's better for him to point out all these materials before the trial court, my lord, at the time of framing charge. If there is no materials, then trial court will discharge him from the
Why
case, my
should-
lord.
why should
How
I-
at this stage from the criminal petition, how your lordship can find out that this is the genuine
I will show
photograph
how
of
your,
that
how lordship
particular
can
road?
find out.
Well, how?
I will
do
show.
not know, my lord.
My brother was saying that this is a road near the High Court. Kindly see page number 25, Lordship. Page number 25. Afterwards, 142 Seema Suraksha Bal. Is it near our High Court?
Maybe, my lord.
Please don't, only because you are a learned PP, don't submit in this
Don't
manner.
make all these submissions because I am
Please,
just
please.
pointing out.
Hold it.
Where is
And
Srinivas
secondly,
Gupta, my lord?
question of embellishment of the money, Lordship. I have not been paid a single penny till today. Why it has not been reflected in the charge sheet? Is the charge sheet only for the purpose of convicting somebody? Not a single penny has been made to me. So the question of embellishment does not arise at all.
Okay, I think these are two FIRs, huh?
But not
Out
to,
of second cause
that
of
aspect
action.
also I would like to point out, my lord, not to FIR, my lord. Your lordship, this is the only the FIR that case has been transferred to my lord Borkhola PO.
Where in the charge sheet it is written down?
Yes, my lord.
Where in the charge sheet it is written down?
Yes, that my lord, I am pointing out from the.
No, where in the charge sheet it is written
Next,
down?
sir, in the petition.
That it has been transferred. Why the charge sheet after
Yes,
15
page
years?
33, then your petition, page 33.
Not my petition, show it from the charge sheet that they have transferred
Order
it.
sheet for magistrate records.
Please show it from the charge sheet that they have transferred it.
Then
No way.
the record, your lordship may call for the record. my lord.
That's a
Please
different
let
issue
me-
altogether.
Lord,
In the meantime, the proceeding may be stayed.
Page 33, my lord. Seen the pair of the eye of Zafir Hussain so and so under Silchar.
No, where it is
Screen
in
for
the 37, page 37.
To OC Borkhola PS, as the PO falls under the jurisdiction of the Borkhola PS.
So you were not sure where your investigation ought to have started. 2 years you have started investigation, 2016 till 2018. 2 years
Okay,
it took for you
alright.
to find out. 2
I'll have
years.
to ponder over it. Stay, I'll have to ponder over it.
Lordship may look into it. I'm leaving it absolutely up to the Lordship. Your Lordship may call for the records, and in the meantime, Lordship may kindly stay.
I'll have to ponder over it.
Lordship.
Well,
Lordship
ultimately,
may.
your lordship discussion, my lord, whatever, I am just pointing out
It's okay,
whatever is there in
It's
his
okay.
petition now.
My submission will be
Because right
adopted
now
only
there is
because
no
the
record.
learned PP is objecting. Kindly do not go by that.
No,
Kindly do
no,
not go by
Well, a question of not of বাৰে
that. আমি কবই লাগিব নকলে কেনেকুৱা হ'ব লাইভ
Then let me also speak on it.
মানাই
It is my duty to point out, my lord.
Yes, yes.
It is my duty, my lord, to point out, my lord. I
Absolutely.
am not interrupting while he is making his argument, but while I am making argument at all time, he is trying to interrupt me. I am so well obstructing my duty, my lord.
How can I obstruct him to do his duty?
Yes, my lord.
It will just more pass already.
Ultimately, my lord, both related parties.
I've
well,
done everything, noted down everything. Huh?
After hearing the argument of both the parties and after my lord pointing out all it is discussion of your lordship ultimately to grant or
Yes,
not, my lord.
Excellent. Lordship is fixing any date, Lordship.
I'll fix a date.
Online will.
Sorry?
We'll have a look in the online there only.
Yeah, yeah. Online, yes.
Diploma. Fix করে নি, করে-
Item 8.
করে ফেলে এসে, ভিতরে গিয়ে দেখে order করে দিতে হবে।
Item 8 for admission.
Wait, please, your lordship. Can you pass over the matter for that?
Pass over for the time being,
No, just sit there.
date, for the date. Learned Counsel Mr. A. Ganguly is present for the petition and Learned
Then media.
Counsel Ms. M. Mehdi has paid for adjournment. List the matter after 1 week, 2 weeks.
Documents, my lord. I have submitted my all these documents, my lord, which has not been considered by the my lord trial court at all, my lord. My lord, in my written statements of my lord, I have my lord stated all these governments, my lord.
Okay.
Kindly see,
Yes.
my lord, kindly see, my lord, DW1, my lord, that is my statement, my lord, at page 29, my lord. Annex 4. Property person, my lord, page 30, my lord.
Oh.
My lord, I have my second wife, widow sister-in-law, bow, and 3 children of my deceased brother whom I have to maintain. I have high BP problem and I have piles and other problems. I have submitted my medical documents before the court. So my lord, next paragraph. First party is a ladies tailor and she earns rupees 10 to 12,000 per month. I have no capacity to enhance the maintenance amount for my daughter and my wife. My lord, this parts, my lord, has not been considered, my lord. My lord, I will pay, my lord, my lord, what happened, my lord? I was paying, my lord, 2,000 regularly, my lord. But subsequently, my lord, from rupees 2,000 to 10,000, it is, my lord, so high, my lord, for me, it is not.
So where is the last pay slip?
My lord, that is in additional affidavit, page 51, my lord. Annex A. I received net amount, my lord, 33,731 only, my lord. And my lord, in the meantime, my lord, I have also taken, my lord, 2 loans, my lord, from SBI, my lord. That is, my lord, page 52 and page 53, my lord. And for that, my lord, I have to refund, my lord, rupees 16,803 EMI, my lord. So, my lord, from my salary, my lord, all this, my lord, I have to repay, my lord, and
Which way? Where is your where is your loan statement?
my lord, policy, my lord, page 52 and 53, my lord. 52, my lord, I have received rupees 6 lakhs, and for that, my lord, I have to pay, my lord, EMI 12,077. Thereafter, my lord, page 53, my lord, I have rupees another loan amount, my lord, rupees 2,59,000. And for that, my lord, I have to pay EMI per month, my lord, rupees 4,726 only, my lord. But including these 2 installment, I have to pay, my lord, rupees 16,803 as EMI, my lord. And moreover, my lord, I have to maintain my 3 nicest minor nice, my lord. My elder brother died, my lord. So I have to maintain them also, my lord. Those facts, my lord, I have brought into record, my lord, in the WS, my lord. And in my DW1 also, my lord. So, my lord, considering this problem, my lord, this.
Lordship, I want to firstly submit the Lordship, this petition has been filed under section 397/401 CRPC, Lordship. Lordship, I'd like to address first what is the scope, Lordship, of 397 and 401, Lordship. In other words, in what circumstances the revision of the jurisdiction of the High Court should be invoked. In this respect, Lordship, I would like to point out one judgment, Lordship.
Must not go into evidence and must file the illegality of the judgment.
Yes, Lordship. Yes. This is 2012 9 SCC.
Yes, in judgment.
It is purely on law and Lordship. Paragraph number 12, Lordship. Paragraph number 12, Lordship. Got it?
Okay. Yes.
Section 397 of the code vested the court with the power to call for and examine the records of an inferior court for the purpose of satisfying itself as to the legality and regularity of any proceeding or order made in a case. The object of this provision is to set right a patent defect or an error of jurisdiction or law. There has to be a well-founded error, and it may not be appropriate for the court to scrutinize the orders which upon the face of it bears a token for careful consideration and appears to be in accordance with law. If one looks into the various judgments of this court, it emerges that the revisional jurisdiction can be involved where the decision under challenge are grossly erroneous, there is no compliance with the provisions of law, and the finding recorded is based on no evidence, material evidence is ignored, and judicial discretion is exercised arbitrarily and perversely. Lordship, this is the position of law under
Yes.
397 409. And kindly look at the judgment, Lordship. I will read the few paragraphs. What is the wrong with that order? For satisfying this honorable court's power to invoke the revisional jurisdiction also. Lordship, page 38, I would like to read from paragraph 9, Lordship, for proper understanding, Lordship, of this court, Lordship. 38 page number, Lordship, paragraph 9.
Okay.
Okay, Lordship, got it?
Yes.
The provisions of chapter 9 of stress. Paragraph number 10, Lordship. The sense in the circumstances refers to a sense in the pecuniary or other circumstances of the party paying or receiving the allowances, which would justify an increase or decrease the amount of the monthly payment originally fixed. Rise in the cost of living amounts to sense in such circumstances, entitling the wife to claim enhanced maintenance. In a proceeding under section 127 CRPC, for enhancement of maintenance, judicial notice, or inflation and rising of cost of essential commodities can be taken by the courts. Rise in the cost of living in an undisputed fact. Since the date of earlier order dated 15/3/2017, till date, the cost of living has increased substantially. Lordship, earlier order was the first maintenance order dated 15/3/2017, Lordship. It was written. Till the date, the cost of living has increased substantially in this almost 7 years. Furthermore, there is a change in the financial position or status of the second party, which should justify an increase of the amount of monthly payment originally fixed in the earlier case. Admittedly, first party is a GOP teacher, Lordship. In a LP school, as per the evidence of second party as DW1, he is now getting 30,000 at that time, Lordship. 30,000 as salary, and as per his affidavit of assets and liabilities, it is 30,396. And prior to that, he was working as a GRS and used to get 12,000, Lordship. At that relevant point of time, 2,000 is too less. He was earning only 12,000, and now he is getting, Lordship, 30,000 at that relevant point. Paragraph number 11, Lordship. The second party, although claimed that he has to maintain his 3 nices, this is very important, Lordship. 3 nices, but he has failed to show how they are dependent upon him. Again, he has deposed that he has his second wife and he has to maintain his widow sister-in-law. As per the affidavit of assets and liabilities also, he has his second wife. Regarding the dependency of his sister-in-law upon him, he has failed to prove it how she is dependent upon him. His sister-in-law and his nieces are legally not supposed to dependent upon him. Lordship, that trial court correctly viewed that, Lordship, because they are not legally liable, Lordship. Because in 125 CRPC, the nieces, the sister-in-law, they are not bound to maintain by the petitioner, Lordship, only on sympathetical ground. Lordship, paragraph number 12, Lordship. Furthermore, although in his statement and in his examination in chief, he has to claim that first party is a ladies tailor, but he has failed to produce any causal evidence in this regard. In his cross-examination, he has admitted that she does not have any tailoring shop and she does not tailoring in her house. If the version of second party is believed to be true, but it cannot be a ground to refuse enhanced maintenance to the first party and their daughter, who are together getting an amount of rupees 2,000 only for last 8 years. A woman stitching clothes at home or does tailoring work cannot earn enough money to maintain her and a school-going child aged at about 9 years. As per the affidavit of assets and liabilities of
All right.
yes, there is no
So should I reduce it to, say, by 1,000?
Lordship, I have objection because her daughter, who is a brilliant student, Lordship, and he has to, Lordship pay her
He has got
fees.
his salary slip. He is earning 33,000.
Yes, Lordship.
16,000 he is paying as.
Yes, no, Lordship, that aspect, Lordship, it cannot be taken into because he recently taken loan after passing that order. Even he claimed that all his money has to be spent with his family. But how he can take loan, Lordship? His version itself is a contradictory, Lordship. She claimed that 25
Financial hardship, my lord, I brought loan, my lord.
Please let me submit kindly, please.
This
This is my turn. This is Lordship. In his written statement, he claims that 25,000 he has to spend with his family. And how he can get loan of rupees of a sum, he monthly paying 16,000 installment. This is not a contradictory statement, Lordship, before this court. She claims that his all expenditure is around 25,000, and she get loan of EMI of rupees 16,000, Lordship. It cannot be, Lordship, and that aspect in this revision petition cannot be taken into consideration because the judgment was passed that time, that was not on the record. And second aspect, Lordship, the judgment of the Honorable Supreme Court in Rajnas versus Neha, this circulated all the high courts of the trial court, Lordship. In that judgment, Lordship, I'd like to show what is the factors to give way to computing the maintenance, Lordship. I am relying their judgment. And what is the purpose of Lordship 125 CRS, Lordship? The wife has always right to live as like she is in her matrimonial house, Lordship. It is well settled now, Lordship. Lordship, first come to paragraph number 13, Lordship.
You have stated that the loan was acquired after this order.
Yes, Lordship, exactly.
How did you come to know?
Lordship, he also served me one, Lordship, affidavit.
Yes. Where did you get? I have this annexure B and annexure C.
Yes, Lordship.
The next.
April 2025, Lordship.
Where?
Annexure A, Lordship. Government of Assam in heading first.
Annexure A?
Yes. April 2025 in the front, Lordship.
Yes.
April 2025, Lordship. And the order was passed way back, Lordship, 2024. That cannot be taken into consideration by a revisional court, Lordship. And Lordship, in that judgment, Rajnas versus Neha, can we come to paragraph number 13, Lordship?
This is not the proper full loan statement.
My lord.
This is not the accurate loan statement. It's not loan amount rupees 6,000 when he has applied, when he has procured the loan. It is not mentioned here. And when the loan, in how many installments the loan will be completed, payment will be completed.
My lord.
Nothing is
Yes,
mentioned.
per month, my lord, 12,077.
Payment is not required. He may complete payment next month also. You never know.
My lord, this amount has been brought, my lord, in the year 2024, my lord. And my lord, there is a, my lord, 72, my lord, EMI that is mentioned, my lord, loan
No,
term.
see, this document cannot be considered. When you give a loan statement, you have to give everything. When it will has to be completed, payment will be complete. You may complete payment next month also. You never know. But
lord,
you may
my lord-
continue paying the loan.
Then my lord, I may be given another chance, my lord,
No, no.
to submit a
No.
detailed amount, my lord.
After hearing for how more than half an hour, no more.
My lord, I have, my lord, submitted this, my lord, I have been submitted these documents, my lord. So, my lord, accordingly, my lord, I place before this honorable court, my lord.
So okay then.
So, my
why
lord,
is
considering I am also,
submitting only the only that small that receipt part.
my
is
lord,
Submitting the
yes, my
receipt
lord.
part.
It is,
How will we understand about the loan?
it
for
is
the
in the
receipt
year
part?
2024, my lord. That is, I have stated in my affidavit, my lord.
After hearing for more than 1 hour, no.
My lord,
Yes.
Is the judgment which I given
Yes,
lordship.
yes,
Yes,
which
I have lordship. It is 2021 to SCC, page 3 to 4 lordship. Start from.
Yes, 3 to 4, which
Yes,
paragraph?
lordship, paragraph number 13 lordship. The Supreme Court lordship framed certain guidelines in their judgment lordship to address the issue lordship. In this judgment lordship, the issue completely addressed lordship. Meticulously lordship. Paragraph number 13 lordship.
Yes, yes.
The guidelines or directions on maintenance lordship. Paragraph number 13,
Yes, yes.
maintenance law have been enacted as a measure of social justice. Lordship, kindly that word, lordship, social justice, to provide recourse to dependent wives and children of their financial support as to prevent them from falling into destitution or vagrancy. Article 15.3 of the Constitution of India provides that 15.3, nothing in this article shall prevent the state from making any special provision for women and children. Article 15.3 reinforced by Article 39 of the Constitution of India, which envisages a positive role for the state in fostering change towards the empowerment of a woman, led to the enactment of various legislation from time to time. Next one paragraph, okay. Paragraph number 14. Krishna Iyer, justice in his judgment in Ramesh Chandra Kaushal versus Bhina Kaushal, held that the object of maintenance law is this provision is a measure of social justice and especially enacted to protect women and children and falls within the constitutional sweep of Article 15.3, reinforced by Article 39. We have no doubt that section of statutes calling for construction by the courts are not petrified print, but vibrant words with social functions to fulfill. The boarding's presence of the constitutional empathy for the weaker sections like women and children must inform interpretation. If it fails, if it has to have social relevance, so viewed, it is possible to be a selective in picking out that the interpretation out of two alternatives which advantage the cause of derelicts, lordship.
Okay, okay.
Yes, Lordship.
All right.
For my humble submission, lordship.
We'll pass the order.
Yes, exactly. I'm deeply honest.
See, I'll reduce it little bit. 1,001.
my lord, I am also, my lord, suffering, my lord, different illness, my lord.
One
That's
person, one person.
medical
Lordship, because of
uh,
that,
down to
for
considered.
the ladies, lordship, only 10,000 lordship, 6,000 lordship.
Only
per-
10,000 for him, my lord, but I only 10,000 is not for me, my lord. It is
Lordship,
big amount for me.
her wife, a lady's lordship, she being a wife of a school teacher, 6,000 lordship, it is not enough, lordship, as per my humble understanding. It is lordship daily to 100 rupees. It is for lordship, it is justifiable, lordship. Considering the status of her status with the lordship, it is low, well settled, lordship. He should live such like such a status, even as if she
Okay,
lives.
we'll reduce it by 500, 500.
Yes, yes,
See, agreed. Reduce by 500, 500, not more. You pay the rest. You see, you have your responsibility towards your first wife
My
and
lord,
child.
now, my lord, my second, there is my second wife, another child also, my lord, born subsequently, my lord. So I have to maintain also them also, my lord. And in that, my lord, in between, my lord, I have to maintain
500, not more. Hard learner counsel, Mr.
A. Hussain.
Hmm?
A.
You
Hussain.
can sit down. Both of you. Please help me out. Learned counsel, Mr. A. Hussain, for the petitioner. নাম নালাগে লিখিবলৈ, and learned counsel Mr. L.R. Mazumdar for the respondent number 1.
AZ Ahmed.
Huh?
AZ Ahmed.
AZ Ahmed for the respondent number 1. Third, learned counsel, learned additional PP Mr. B. Sharma for the respondent state. You have to say something.
No.
Formal party. This is an application under section 401(397) of the Code of Criminal Procedure. Read with, are you sure this is after, before the
Exactly.
BNSS? Are you sure this is before BNSS, no?
My lord.
Read with section 482 of the CRP, Code of Criminal Procedure within bracket CRPC for short, challenging the judgment and order dated 16/2/2024 passed by the learned Chief Judicial Magistrate South Salmara, Mankachar, in connection with Miss Case number 50 of 2022. Post of the petitioner is aggrieved as the monthly maintenance has been enhanced from ₹2,000 to ₹10,000. Post of the petitioner is directed to pay ₹6,000 as monthly maintenance to his first wife and ₹4,000 as monthly maintenance to his second wife. It is submitted on behalf of the petitioner that the petitioner is a school teacher and his present net salary is
₹33,731.
33,700. This is net salary or gross?
Net salary,
Net
yes.
salary. 33,731. It is submitted that the petitioner has to maintain his sister-in-law, 3 nieces, and his second wife. Full stop. You have a child now, or you
Yes, my lord. Now my M-7.
The petitioner is at present blessed with a child from his second wife, and he has to take care of his entire family as well as his extended family. Full stop.
And also I am
Maintain his
medically also, my
So
lord.
it is further submitted that the petitioner is a patient of high blood pressure.
And files and other problems.
These submissions were made while the petition for enhancement was enhancement of maintenance allowance was submitted by the respondent, but these submissions of the petitioner were not taken into consideration by the learned trial court while directing the petitioner to pay the enhanced maintenance amount.
Moreover, in the meantime, my lord, I have taken loan, my lord.
It is further submitted that the petitioner has also procured loan and he has to pay
16,000.
12,077 plus ₹4,726 is equal to ₹16,803 as EMI for 2 loans procured by the petitioner. Full stop. The petitioner is left with the petitioner has to is left with is not left with sufficient amount to maintain his present family. Full stop. The petitioner has also drawn the attention of this court to the evidence adduced by the petitioner as DW1, wherein he has stated
Is 30, my lord.
wherein he has categorically stated that he has to maintain his second wife, his sister-in-law along with 3 nieces. Full stop. He has also categorically stated as DW1 that he is a patient of high blood pressure, piles and other problems. Full stop. He has exhibited the medical documents in the proceeding of the missed case, in connection with the proceeding of the missed case number 50 of 2022. He has also categorically mentioned that the respondent is opposite party stroke respondent is a ladies tailor and earns around rupees 10 to 12,000 per month. The petitioner has prayed to reduce the enhanced maintenance amount as his elder brother has passed away and he has to maintain his brother's family as well. Full stop. The learned counsel for the respondent has raised that's per contra. The learned counsel for the respondent has raised serious objection and has relied on the decision of the Honorable Supreme Court in Amit Kapoor versus Ramchandar and another reported in 2012 9 SCC 460, wherein it has been observed that para 12. It is submitted by the learned counsel for the respondent that there is no illegality in the order passed by the learned trial court, and the order is not required to be interfered with. Full stop. Sound reasonings have been assigned by the learned trial court while disposing of the petition under section 127 CRPC. The learned counsel for the petitioner or respondent has drawn the attention of this court on the judgment of the learned on the decision on the order of the learned trial court wherein it has been observed that
Paragraph 13 and
to page 38 page 38 paragraph 9, page 38 of the petition, page 39. I find force in the argument on behalf of the respondent. Full stop. The learned counsel for the respondent has also relied on the decision of the Honorable Supreme Court in Rajani versus Neha.
Two 2021 2 SCC 324.
Reported in, you'll leave this book with us. You take it back tomorrow.
Okay, Doctor, I have the judgment.
Yeah, yeah.
I have copy of the judgment.
Okay. You give it to me then.
And otherwise, your lordship can, this is the
It-
court's books, lordship can keep, lordship.
This is from our court.
From library,
Library from
I'll
library.
take back, yes.
We'll keep it, then we'll send it back to the
Okay.
library. No.
Okay, I will take back, lordship. I will take back.
Okay, we
No.
take it back tomorrow. Okay. Paragraph, Hari.
Lordship, paragraph 13 and paragraph 90 is a relevant, lordship, for quantum and the maintenance.
No.
Lordship,
Now you'll not bring in new paragraph. You have not quoted.
okay,
13.
lordship, paragraph 13 also.
Paragraph 13 or 14. I have considered next I have considered the submissions at the bar with circumspection. I find force in the argument on behalf of the on behalf of the respondent who stop. The learned trial court has what about the respondent?
Respondent, I have taken their consent. They said that they have no objection.
Okay.
But then we want that matter should be disposed of earlier. We are the
Yes, yes.
appellant.
When do you want?
Immediately after vacation.
Yes, yes. Learned counsel, Mr. J. Sharma,
Yes.
with the consent of the other side, has prayed for adjournment. List the matter dated the List the matter on 22nd July for hearing positively, as this is a long pending case.
Item number 29, I'm sorry, okay.
For hearing a Singapore. IA hearing.
IA here.
For IA, man.
Notice ruling as a full hearing process.
Item 20, na?
29, 30 to 9.
29.
29 IA.
For IA lottery, we have filed the objection lottery. Otherwise, for the hearing lottery, I need some time.
No, if you-
29 or 30, no?
30 is already, my lord, that is not, that is tagged because out of the same, he already got bail, my lord.
Okay.
It is tagged because out of the same judgment.
Today discuss for final hearing.
Final hearing?
Yes.
No, no, my lord, it's the IA,
Please column.
hearing column. I do not know, but actually your lordship fixed for IA, my lord. That as I,
So she was submitting that she will file objection.
Objection has already been filed.
Obviously the fact.
To the report. Need some time.
Let us give her some time. And we'll hear it finally also if
Yes,
possible.
Finally, normally does not come, my your lordship, before the keeping in view of the pending cases, my lord, sometime.
The hearing column.
And
Order. So file-
Or then we will take it back to the orders column.
Yes,
Yes.
yes. let
that
it-
will better, my lord.
Take it back. to
Your
order.
lordship, order column, any date next to come, any day.
Sure.
Why are you apprehending that we won't hear it finally?
My lord, we find that so many cases are pending, my lord. It may not be taken because
Only 3 cases are pending. They have actually, why the list is so long, I do not know on hearing dates.
Yeah.
They should not have given such
that's.
a long list on
that-
their hearing
The
dates.
suggestion should go from your lordship, my lord. We cannot ask them, my lord. But the humanly possible, it must be given. We also,
We will fix it for final hearing, and if we do not hear it finally, we'll take up this
my lord,
I.
my lord, IA may be taken, my lord, IA, because hearing, I doubt, my lord, will come. Let it come for order, my lord, IA, my lord. Yes, ma'am.
I have also filed our.
Our learned senior counsel, Mr. H.R.A. Chaudhary, and learned additional PP, Ms. N. Das. Full stop. Learned additional PP has submitted for time to go through the record to place her oral submission, or to place her oral objection. List the matter on
16.
in the orders column.
16. In the meantime, I made additional affidavit help them.
In the orders column,
Yes, madam. In the meantime, we will file, but he is very seriously ill, my lord, we will file some paper also.
And he's admitted, Lordship.
Yeah.
Today he's already admitted in the hospital.
in orders column, dictionary. All right,
On 16.
on
Number photo.
16 koila na?
I have another item, 28, my lord. That also come actually about 3.5 years already, my lord, out of 10 years.
I think.
I have pending, my lord. So same, my lord, I pay, subject to your lordship's, my lord.
এইটো আগতে আইএ টো লিখি পেলাই উইথ এপিল বুলি দি দিবা দুইটা কেছতে
28, my lord. This says,
কলম লিখি দিবা
yes, order column,
one is 28 no
28.
and one is 31
No.
30.
oh 29
and 30.
oh 20
Oh, objection file, my lord, objection file.
29, 30.
Oh, 29, 30, my lord, yes, that.
এইটো দিলো এই মাত্ৰ
এইটোতো হৈ গ'ল 28, 9, 30 হৈ গ'ল না? Only 28, my lord. But the same day, your lordship, I will be available, madam. That.
Same day possible, Papa, full of, not possible. Some other day, not possible on the same.
17.
Somehow we can,
18, madam, 18.
18.
Last day, madam.
It is 18 লিখে দিবা।
Yes. Huh?
It is 28 to
20.
18 of 20.
No, 20. Obliged to yours. Order column, madam.
Or order column, yes.
Both.
I with এনেকে লিখি দিলে তেতিয়া order column লৈ গুচি আহিব নহলে আকৌ ট্ৰেনিং লৈ গুচি যাব। দুইটা লিখি দিবা।
16 না 17
Wait a
19 16 সোমবার হয় দেখি
হবে একটু no problem.
আর argument Yes, sir.
Let us do quickly.
Yes, yes, they finish everything.
Lordship, here, your main contention is that non-compliance of certain provision of NGT.
Yes, yes.
Before that, Lordship may come to evidence of PW two.
From para, you can read also what they have submitted. I have already typed para 7 to para 11. Huh? He has submitted
We have taken, my junior have taken note.
notes, then it's okay. Evidence of PW?
PW two, PW three. Lumkola,
Evidence of PW?
PW three. That's the IO.
Yes, yes. The longest deposition ever. You'll go to cross examination.
Lordship, I am from examining chief is.
For examination chief.
Because Lordship, their contention is that section 42 was not complied with. Basic argument is of the my management was there. Then another Lordship 52 was not complied with, 52A.
Yes. Section 42 and
52A. Sample was not collected before the 100 by.
yes, yes,
That law has been changed now
yes. Because of the judgment.
of Bharatambala.
Huh?
Bharatambala.
New judgment, no? The new
Today,
judgment.
first up, I was arguing for middle bench of court. There was the main contention of the petitioner, the appellate, that section 52 A was not compliant. May I place lots of evidence of
Yes.
3. On 20th, then court on 28th January 2017, I was posted as the details officer, the NCP God unit. On that day, I received the information about 7 a.m. in the morning that one oil tanker bearing registration number so and so, bearing consignment of Kanja coming from Manipur will reach at Kitamlu Road near ISBT petrol pump, Guwahati, at around 9 a.m. On 28 January 2017. Thereafter, I put the same into writing and submitted to my zonal director, Praveen Kumar, and movement order was given by zonal director LCB team, comprising of me, that is Jalkhan Lal. You mentioned some name of some officer is there. Then exhibit 1 is the LCB, exhibit 1 of my signature, exhibit 2 is the zonal director. This is the compliance of section 42. So, now
NDPS.
Lordship, and suddenly I have seen one production list, Lordship, my matter is listed, but no brief with me, Lordship. And so can it be day after tomorrow, Lordship?
Production list.
Lordship. And otherwise, my lord, Otherwise, my lord, the.
On 17/6
See,
then.
the main accused lordship, main accused already been granted by your lordship, and I am in about more than 13 months in
But
custody.
you are asking for, you are asking for adjournment today?
Lordship, day after tomorrow can it be lordship?
Whom take us?
But is
Not
all
day
are
after
the
tomorrow.
separate lordship.
Yeah, entire matter, all the matters are fixed on 17.
Lordship and all are different matter, lordship, not same PS, different matter. So can it be more than 13 months in custody, lordship? And another matter is Dr. Enzo Datto is lordship and on matter.
We'll take up all the matters together on 17. Others PP won't place his submission. No point hearing you part hard, then we'll again hear the PP, then I'll keep forgetting your submission.
But otherwise,
17, when is 17? Today is today
10,
is
10 lordship,
10, 1 week.
lordship.
You're behind bars for how many days?
13 months of 14 months is going on, lordship. 1 year,
What
2
about
months.
contraband?
And lordship, some lordship heroin lordship. And the
Ah.
co-accused already, accused number
Heroin,
one
how
already
much heroin?
1.268 gram lordship.
1 kilo
1 kilo lordship.
on 17th, on 17th, on 17th.
Lordship.
Lihiria. You want to select case number? Learned Counsel Mr. Fogg has prayed for adjournment. List this matter on. Huh?
In item 33,
Item 33, yes.
I have filed one additional affidavit, your lordship.
For grounds of arrest.
Yes, yes.
Yes.
Page 49, your lordship.
Hmm?
Page 49, your lordship. In my additional affidavit, I have brought the notice served under section 50 of the CRPC.
49, okay.
There is no such ground of arrest. No such ground of arrest has been mentioned there in your lordship. And regarding this issue, your lordship, on the last occasion, your lordship, I made my submission, your lordship. I am seeking bail on that ground also, as well as the merit of the case, your lordship. Merit means.
No. Not on merits of case.
Yes, on
You
that
stick
ground.
to your grounds of arrest only.
Yes, on that ground only, your lordship.
Merits, I will not decide this bail on merits.
In the judgment of Probir Purkasto as well as VN Kumar and also judgment, your
You have
lordship.
given a judgment.
Yes. Yes, sir. Probir Purkasto, yes. Probir Purkasto, VN Kumar.
Judgment of Probir Purkasto, and it doesn't matter, you may not give. I have too many copies of
Yes,
those
yes.
judgments. Judgments of Probir Purkasto and
In para 20, 22, 30 and 46 in Probir Purkasto.
para
20, 22, 30 and 46.
para 20
20, 22, 30 and 46.
and 46, okay.
And thereafter, in VN Kumar, your lordship, 15, 14, 15, 20, 21 F.
Vian Kumar 14,
14, 15, 20 and 21 F.
you give the relevant.
Yes, yeah.
You give one relevant paragraph.
Yes, yes.
Not so many paragraphs.
Yes, but now-
You just think about
Yes.
them also. How much will they type? Probir Purkasto and Vian Kumar. See, you read out 20, 22, 30, 46 in Probir Purkasto. So you give one paragraph.
Yes.
Relevant paragraph.
Yes,
Not 20,
Now-
22, 30, 46. One paragraph.
yes. Now regarding prospective, your lordship, on that issue, because on last occasion, my friend, your lordship, basically he submitted that the application of all the laws.
Just a moment. Vian Kumar's which paragraph? Give one relevant paragraph, not the submission of the advocate.
Yes, yes.
then all
Yes.
that. No, no, no. I don't want the judgment. I have copies to so many copies.
I'm reading your lordship for para I would like to rely here. Lord.
Gyan Kumar.
Yes.
No, no, you won't read it. I know. I know all the paragraphs by heart. You
The-
won't read it.
Yes. My submission is one
Which
that
paragraph you want to rely on?
21F, your lordship. That means in all judgment, your lordship, it is well settled that where there is non-compliance of that requirement, your lordship, it amounts to violation of fundamental right. And VN Kumar judgment talks about that where there is a violation of fundamental right, even if there is statutory restriction, then the violation itself overrides the restriction, your lordship. And that one, your lordship, I am reading, your lordship, only the relevant one, your lordship. When a violation of Article 20.
No, 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 you won't read it. Please don't.
Yes,
read
yes.
it.
I have already given your lordship and I have highlighted that. Now regarding prospective and retrospective effect, your lordship, that. Yes, and that issue is already settled by ordinate bench of this Honorable High Court, your lordship. In the light of the judgment of the Honorable FX Court, your lordship. And what is the assumption? Give it. Which I believe. Prospective and retrospective effect, your lordship.
Which paragraph?
Page 4, your lordship, kindly.
Page 4?
Yes,
Page 4, yes.
yes. I'm reading it, your lordship. Now the law of prospective and retrospective
Page-
operation. Yes,
Which paragraph?
it is connection, Shinha and another, your lordship. The judgment of the FX Court, your lordship. Page 4, your.
Yes, yes.
Now the law of prospective and retrospective operation is absolutely clear. Where a law made by the legislature is always prospective in nature unless it has been especially stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by a constitutional court or law as it is interpreted by the court. The judgment of the court will always be retrospective in nature unless the judgment itself especially states that the judgment will operate prospectively. Only this is, your lordship. And regarding this, your lordship, our High Court, your lordship, I have given that one, your lordship, in Shahidul Islam Bapari, in that case, your lordship. Para 18, your lordship, kindly. Sixteen also, your lordship, can. Para 18, your lordship.
Yes. Right.
Yes. Though in the case of Pankaj Bansal Supra, the word henceforth was used, meaning thereby from the date of pronouncement of the judgment, the law laid down therein would be applicable. And one such count, Honorable Supreme Court has refused to give effect of the same retrospectively in the case of Ramkishore Arora. And one such count, the submission Mr. Bhattakur has some force, yet there is no such direction in the case of Byan Kumar regarding prospective effect of the said decision. That being so, in the view of the proposition of law so laid down in the case of Kanik Sinha and other, judicial decisions are presumed to have retrospective application unless mentioned otherwise. That being so, the court is unable to report concurrence with the submission of Mr. Bhattakur, the learned additional public prosecutor. That means that plea was, the same plea was advanced before the advance, your lordship, but it was not considered, your lordship. So it is clear from it that that submission of prospective and retrospective, they cannot raise that plea because all the judgment, nowhere it has mentioned that the judgment will operate as prospective manner. So my submission is that, your lordship, now if your lordship will go by the judgment of Byan Kumar, then it is well settled that there is a violation of fundamental
No,
right.
but if we refer to the judgment now, the latest judgment, then we do not require the grounds of arrest to be communicated in details. The new judgment by Justice Patiwala. So if we go, if you go by that judgment, then we don't have to go into details, the grounds of arrest. Once you explain it to him, then it's fine.
But in the case of Shahidul Islam, your lordship, that case, your lordship, kindly see, in that judgment, your lordship, in that case, your
Then we
lordship,
will take into account your submission then and we will go to that new judgment.
new judgment.
That it has no retrospective effect. So now now onwards, we will follow this new judgment. I've forgotten the citation.
But in all the judgment, your lordship, nowhere it has mentioned that the judgment will operate
Yes,
as
now I'm agreeing
prospective or
with you.
retrospective.
Now I'm agreeing with you and I'll take up the new judgment. We'll take up the retrospective effect then.
New judgment, which one, your lordship?
I forgot. I'll search in the website and then I'll bring it. I've forgotten.
I have not found, your lordship, any such judgment. That
You'll find it. Okay, I'll keep it reserved because everybody has to submit on the same line. গোটেইখিনি একেলগে দি দিব ন? Yes.
one more, your lordship. If your lordship will consider the merit, apart from the legal position, your lordship, even
How many witnesses have been examined, sir?
altogether, there are 7 rounds of witness, your lordship.
7 witnesses?
Yes.
And how many witnesses have been examined?
I think 5 has 6, ne? But the material witness, your lordship, they have not supported the case of the prosecution.
What tablet?
Tablets, your lordship.
What tablet? Hmm?
1,224 numbers of Tramadol capsule, your lordship.
1, 2, 2, 4. Tamarol capsule. Tramadol or Tamarol?
Herein it is written as Tramadol, your lordship.
Tramadol.
Within 1 year, 6 witnesses examined.
Huh?
Within 1 year, 6 witnesses examined out of 7.
And as for my instruction, your lordship, that is the FSL expert, I think so far. But the PW 1 and 2, your lordship, 1 and 2 are the senior witness, your lordship. They have not supported the case of the prosecution.
No, I'll not get into the decision.
This is
Because,
apart from the legal position, your lordship.
Examine, I'll not get into the decision.
This is apart from the legal.
Examine the merits because so many witnesses are examined. The trial court, it will be like nudging the trial court. You decide this case in this manner then. Okay. গোটেইখিনি একেলগে ক'ব ন? Item 34.
May I please to lordship?
চব একেলগে ৰাখি থৈ দিব, একেলগে এটা group কৰি দিব।
My lord, kindly see the FIR, my lord, page 17.
Page 17, yes.
Yes, my lord, FIR.
Hmm.
My lord, kindly see page 18.
Page
All-
18, yes.
Page 18. Altogether 4 accused persons. Abdul Hamid, Zabel Hussain, Mujibur Rahman, and Abdul Hashim. These, my lord, these 4 persons are found in possession of 300 gram tablets, Yaba tablets. And out of these, all four, my lord, three have been granted bail by your lordship.
Okay.
Zabel Hussain granted on 8/4/2025. And Mujibur Rahman granted on 16/5/2025. And Abdul Hashim granted on 14/5/2025.
Only Abdul Hamid.
Only Abdul Hamid remained, which is IMB. And my lord, what happened, my lord? This is my second bail application. Kindly see page 39, my lord. My earlier bail application.
Okay.
In that bail application, your lordships ordered for an expeditious trial. And thereafter, my lord, due to prolonged incarceration, only one PW examined. And on that prolonged incarceration ground, your lordship granted 3. Only I am remained, my lord.
How many days you are behind bars?
I am 2 years, 1 day. Today is 2 years, 1 day. Arrested on 7/6/2023. It is 2 years, 3 days, my lord. 2 years, 3 days.
How many witnesses are examined?
Only one witness examined.
How many witnesses are enlisted?
It is, my lord, it is 11, my lord. So far, total, my lord, I'm saying 8 PWs, my lord, were arraigned. Page 29. 8 PWs.
1 out of 8 PWs.
One, yes. And my lord, kindly see, on the other day, I have submitted all the bail orders of 3, my lord. This is, it is on record, my lord. So, my lord, only I am remained. On that very ground, my lord, it is unjustified to remain in custody, my lord, in my case.
Here in this case, lordship, one witness examined, lordship, and
What's the contraband? How much contraband?
Contraband 300 grams, Yaba tablets.
All right.
on
Let
the-
him go on bail.
lordship, only on the ground of long incarceration, that way it is not
Let him
long
go on bail.
incarceration. There is
Too
some,
long.
lordship. Long incarceration, that may not be ground for
No, no. Can be a ground.
in Kalyan Shankar Sarkar case, lordship.
Only
is-
one
is-
examined. This is not 4 or 5 kgs of Yaba tablets, 300 grams of Yaba tablets. Third learner counsel, Mr. Ikhar Chaudhary for the petitioner. Abdul Hamid.
Yes.
Who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 7/6/2023, i.e. 2 years, how many?
3 days.
On the ground of long incarceration.
Yes. No known grounds of arrest. 2 years, 3 days, behind bars since, in connection with special NDPS case number 59 of 2023 arising out of clearance of PS case number 7/2. Third, Mr. PS Law or learned additional PP ASA. The petitioner has paid for bail on the ground of parity. It is submitted that the petitioner was arrested along with other 3 co-accused who have already been enlarged on bail. Full stop. It is further submitted that the petitioner has been undergoing prolonged incarceration and only 1 out of 8 enlisted witnesses have been examined so far. Full stop. His right to personal liberty has just been curtailed. The learned additional PP has raised serious objections stating that the petitioner is booked under a heinous offense of transporting 300 grams of Yaba tablets. It is submitted that, it is further submitted that in case of heinous and severe offenses, the prayer for bail on grounds of parity and on the grounds of prolonged incarceration is not sustainable, is not tenable, is not tenable. The petitioner has also relied on the decision of the Honorable Supreme Court in Dhirendra Kumar Chaudhary versus the state of Assam, where invite order dated 14/8/2024 in criminal appeal number 3379 of 2024. The appellant Dhirendra Kumar Chaudhary was granted bail for incarceration for 17 months. Full stop. I have considered the submissions at the bar with circumspection. I have considered the submission that the petitioner's right to personal liberty has been curtailed due to the procrastination of trial by the court as well as by the state. I have considered the facts and circumstances of this case. I have considered the peculiar facts and circumstances of this case. It appears that bail may be granted to the petitioner. Full stop. The petitioner has pledged to cooperate with the trial as well and to abide by any stringent bail conditions if imposed upon him, considering all aspects and in the light of the decision of the Honorable Supreme Court in Dhirendra Kumar Chaudhary Kothul negi? Dhirendra Kumar Chaudhary's case Supra, petition is allowed. The petition is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which he is alleged. The petitioner shall not leave the jurisdiction of the court without prior permission, and the petitioner shall cooperate with the trial. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
Item 35.
In respect to my item 35, just to place one minute page where the facts are listed. He has been in custody since 3 years, 7 months. Kindly, my lord, have a look of this page.
No, but I want to know what is the contraband. You see, the contraband also counts.
In this case, my lord, contraband, my lord, only 845 grams of Yaba tablets.
Only.
My lord, kindly see
845.
how the prosecution violated your lordship's order, my lord. Kindly see, my lord, what happened in this case. Very unfortunate, my lord.
845 grams of?
Yaba tablets, even not in 1 kg, my lord.
As good as 1 kg.
Yes, my lord.
All right.
My lord, kindly see for a moment, my lord. Page 22, my lord. Page 22. The first bail application of the petitioner is there. It was rejected on 18/1/2024. Your lordship passed this order. Thereafter, my lord, the petitioner again approached before this court. And my lord, in that case also, Annexure 4, page 22, in page 24 in middle portion, how, my lord, the case was, it is written as, it was fixed on evidence on 29/9. So many dates were there, but evidence were not taken. Your lordship passed the order for expeditious trial. Thereafter, my lord, the petitioner again approached before this honorable court, page 27.
Break no law.
Now, my lord, kindly see page 27. This is the second bail application. Your lordships ordered on 5/9/2024. There also, my lord, page 29, my lord, your lordship specifically ordered for expeditious trial for speedy disposal of the case. Page 29, my lord, kindly see.
Okay.
Yes, my lord. However, my lord, the evidence taken last PW4 was taken page 48. I have annexed, my lord. Page 48. It was taken on 13/9/2023. On 13/9/2023, last PW is examined. And thereafter, your lordship passed two orders repeatedly for expeditious trial. But till date, no PW is examined. My lord. And I have been in custody since 3 years, 7 months.
How many witnesses have been examined
4 examined
out of
6. And that last 4, my lord, examined on 13/9/2023. And your lordship passed after 13/9/2023, your lordship passed two orders for expeditious trial. But till date, prosecution has not examined any. So my humble submission, my lord, it is a clear case of prolonged incarceration and the violations of the High
No,
Court.
but the PP is not prepared for prolonged incarceration today.
Yes.
Now he'll go to the LCI. He is prepared for grounds of arrest today.
So my lord, in this case,
Lordship, here sufficient progress is there, Lordship. Out of 6 witnesses, Lordship, 4 witnesses has been examined, Lordship. And the next date is fixed, Lordship, 17/6/25 for further evidence, Lordship.
my lord, since
So, Lordship, on the other hand, Lordship,
See, last witness was examined on 13/9/2023.
that is I am going to say,
Yes,
why,
ma'am.
why
Year,
this delay,
10
Lordship?
months back.
that I have
that
annexed,
order
that
is-
I have annexed, my lord.
1 year, 9 months back.
That order is. punished
1 year,
with the-
9 months.
Whether that order is punished with the court or not, that.
And my lord, I would like to place this order to your lordship on that specific ground, my lord. Your lordship granted bail. And here, my lord, only 2 years, 7 months. And I am 3 years, 7 months. So, my lord, it's a very unjustified for me, my lord.
In
On that
case,
very
Lordship,
ground. There also, my
in
lord.
case will go, Lordship, yes, in that case, Lordship, because Lordship, if out of 6 witness, 4 witness examined, 5th witness is on next day, Lordship, and it is the trial comments from door 22, Lordship, but it is 23, Lordship, it is not 1 year, Lordship, it has been gone, Lordship.
13/9/2023, last witness was examined.
Yes.
In the month of September 2023.
I have annexed it.
This is not on length of detention.
So, my lord.
This is Probri Procastor's case.
No, no, my lord. This is on the same footing, your lordship granted bail, same footing. And my case is more stronger than that case. Here in just 2.5 years, and I am almost 4 years, man, 3 years, 7 months. On that very ground, my lord. That was granted on that ground, that yes, last PW is examined so and so date. And after prolonged date have been gone, but no PW is examined later, my lord. So, my lord, in this case, my lord, I deserve bail, my lord. Any condition.
Let me hear him.
That whether that I am going to search, Lordship, Lordship, that whether that order has been punished before the court or not, Lordship, because Lordship order.
And that punished, my lord,
Because
that
that has to be-
punished, everything punished.
Let him check, let him.
My-
Give him some time, let him check, because he is coming prepared for another argument, because all of you are arguing on one point.
My-
Suddenly you come up with this point. All these days you are arguing on Bihan Kumar and suddenly you come up with this point. Not pressing Bihan Kumar anymore now.
And whatever my information, my lord, the repeated summon was issued to that PW to come before court, but he is not, my lord, attending. This is the trial court lawyer told me.
পাঠিয়েছো? এই যে দেখুন, ওই বলবে।
The IO was transferred to another posting, Lordship. That is why, Lordship, some lapses are there, Lordship. It is reflected in the order sheet also, Lordship.
IO
Thereafter, Lordship, bailable warrant has also been issued, Lordship, thereafter to the witnesses, Lordship. Also, when case is fixed on, it is fixed on next 17/6/25, Lordship. Then lordship make a bit pending lordship. Let us see whether on the day any witnesses can come or not.
My lord,
Because lordship out of 6, if it is come, it will be 5 lordship. And at the last stage, whether bail is required to be granted or not lordship, because it is a commercial quantity. 250 gram is the commercial.
He's from which
800,
place?
Sribhumi, my lord.
800.
Huh?
Sribhumi.
Sribhumi.
My lord,
800
3 years,
grams
7 months, my lord. 3 years, 7.
Sribhumi.
Sribhumi.
What is his age?
Age is, my lord, it is, his age, my lord, I am written here. His age is 40 years now. And my lord, 3 years, 7 months. Since 2021, I have been in jail. And 1 year, 9 months have gone, no PW exam. So my lord, I deserve bail, my lord, in this case. And nowhere I will go, my lord. My family is there. I will appear, my lord, if the bail is granted. Because, my lord, in other cases, my lord, 1.5
This is pending in Sribhumi?
Yes, Sribhumi. It's pending in Sribhumi. In any condition, my
All
lord.
right, all right. 6 witnesses have been examined, so you cannot say that, but you see that gap is too much.
That is where lordship, and the next date is on 17/6 lordship. Lordship may kindly fix it on 25th or any other date lordship, so that
My
if
lord, my
anything
humble
else,
submission, my
presents
lord,
till
if
then
your
lordship,
lordship
you
grant
will
bail,
also
my
know
lord,
whether
I will appear, my lord, on that day. There is no question of
I don't know
postponing
lordship,
here.
why even after 4 witnesses has examined, only because of
I have
that
the
gap,
family,
lordship,
my
as to
lord.
the IO is changed from one place to another
I am
place,
the father
there
of
may be
3
some
children, my lord.
gap lordship.
Where I will go, my
Court is not sitting for only one case. You know the burden of the court itself also lordship.
And when
At the same time,
1 year, 9 months
now
have
it
gone,
is-
not PW is examined. So it is a clear case of, my lord, in prolonged incarceration. And your lordship, 2 repeated orders
We are saying-
for expeditious trial. Even the
And
violations
the
of
court
court's
will
order.
lordship, the special courts are not so much courts are there lordship.
So this is my 3rd bail application, my lord. Consider that aspect. This is my
Every
3rd bail
cases,
application.
So
not
everything
first, my lord.
in most of the cases comes in the special court lordship. So lordship, it is the
after-
burden of the
after-
court also lordship.
After
We have to see
receiving your
to that
lordship's order, I am approaching again before that court, my lord. However, till date, not PW, even both,
That
your
is-
lordship, both order passed after 13/9/2023.
That is why
That
honorable
PW
apex
is
court
for
has,
examination. 2 orders passed, my lord.
honorable apex court has also stated that
So, my
there
lord,
is a
that-
now speedy disposal, speedy trial should not be given. Full bench judgment is there lordship. For wherein it is stated lordship, speedy disposal, speedy trial should not be given.
So under such
any cases,
circumstances, my lord,
Because of
under such circumstances, I should not be.
Allahabad High Court
detained
persecution
till date.
cases, dear lordship. It is stated, there should not be any speedy disposal. Speedy trial. So lordship.
So my humble submission, my lord, your lordship, transfer, my lord, because this is my 3rd bail application, not first one.
There's Supreme Court's order that there should not be direction for speedy disposal within so many years, so many months.
This submission is now, whatever I'm encountering this submission because the speedy disposal order passed much earlier, my lord. And at that time, my lord, the learned trial court or the prosecution should follow that order. So for that period of time, that speedy disposal order was exist. It is not today, not passing today, your lordship, my lord. Your lordship passed already orders. So trial court is binding up on your lordship's order, my lord. So my humble submission, 3 years, 7 months, not 1 year.
Also because whether he is entitled for such a bail or whether such crime is heaviness or not, lordship will decide lordship. Because lordship, person who is wherein lordship 4 witnesses examined, 5th is on 17 lordship. Only because of that gap, lordship, he is entitled for bail. And what is his grievance of his gravity of his offense? That has to be looked
1 year, 9 months.
only
my lord.
1 and 9 months lordship. So
No
many persons
progress
have
of
died
trial.
because of that crime.
If we take, my lord,
Only
3 years,
1 year, 9
3 years, 7 months, 1 year, 9 months have been
Persons
gone
left the world.
without
They-
progressing any trial, my lord. How without progressing any trial? I have been kept in custody for 1 year, 9 months, my lord. It is a clear violation of section 21, article 21 of constitution, my lord.
Okay, we'll consider your submission after the date of evidence. Okay. After the date of evidence.
My lord, at that date, almost 20 to 25 days have gone. 20 to 25 days have been. My humble submission, my lord, father of 3 children, my lord. Nowhere I will go, my lord. 3 years, 7 months have been in custody. I will appear, my lord, if your lordship on that day, very date, I will appear. Nowhere I will go, my lord. And your lordship, my lord, passed on a similar circumstance, your lordship passed even in lesser custody period, my lord. My humble submission, my lord, I will appear, my lord, in every dates. 1 year, 9 months have gone, my lord, without any progress of trial. Clear violation of article 21, my lord. So in that case, my lord, No more submission even required. It's a clear case, my lord. Prolonged incarceration. Article 21 is violated, my lord.
All right then. After, on your objection. Okay, prolonged incarceration on your objection.
Learned previous objection may be recorded, my lord. Bail may be granted. my lord.
By Learned Counsel, Mr. H.R. Chaudhary, for the petitioner Mohammed Sahid Ahmed alias Sahid Ahmed, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 10/11/2021 in connection with NDPS case number 96 of 2021 arising out of DPS case number 450 of 2021 under section.
What does not reveal lordship, that lordship, the last order lordship, that he has submitted that order lordship, that I have not found lordship.
Actually,
Even the LCR is there.
actually, it's okay. I don't think so. They have punished the order. I also don't think so. But what is appearing on that record, then that much of I have taken into consideration, and I'm not very happy with the amount of contraband he's been transporting. But I have considered that he is father of 3 children and he is age 40. All this I have taken into consideration. But he must behave like a father of 3 children. He's not behaving like one. He's spoiling other children,
My lord, offense was
selling yaba tablets to youngsters.
offense was committed 3 years, 7 months back, my lord. Later, my lord, I have rectified myself, my lord.
It is submitted on behalf of the petitioner that as the petitioner has been behind bars for 3 years, 7 months, his right to personal liberty has been curtailed as trial has been procrastinated by court as well as by the state. As the last witness was examined on 13/9/2023. Thereafter, not a single witness has been examined. The learned additional PP, Mr. P.S. Loper has raised serious objections stating that 6 witnesses are enlisted as cited witness in the charge sheet. Full stop. 4 witnesses have already been examined. The case is at the fair end of trial, and the petitioner is not entitled to bail at this stage. The petitioner has committed the heinous offense of transporting 8,000 yaba tablets, which transport peddling of drugs is a menace to the society, which has destroyed many youths of this country. Full stop. Deterrence is the rule of the day. Full stop. I have considered the submissions at a bar with circumspection. The petitioner has pledged to cooperate with the remaining part of the trial. It is submitted that the petitioner is a local resident and he is not a flight risk. It is further submitted that the petitioner is a father of 3 children, aged 40 years, and his family is in facing immense hardship due to the prolonged incarceration of the petitioner. It appears that bail may be granted to the petitioner. Considering all aspects, the petitioner is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall appear before petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. The petitioner shall refrain from such activities with which is alleged. The petitioner shall refrain from such activity. The petitioner shall not exercise threats to the witnesses or jump the bail on breach of any of the bail conditions. The court is at liberty to cancel the bail immediately, cancel the bail granted to the petitioner. All right.
God bless you.
Please, your lordship. Madam, As per the charge sheet, when it was on 14, the police conducted a raid and at the place of Bablu Elias Safiku. From there, they found some contraband.
Mm.
Subsequently, based on his information, I am arrested. Nothing has been found from me. Now, the person from whose possession the alleged contraband has been found, he has been enlarged on bail. And based on his information, 3 people are arrested. I, Suman Roy, and there is a third person, my lords, Johirul Islam. Johirul Islam is also given bail. Now, my fate is before your lordship. I have been behind bars since 663 days, 22 months. It's almost 22 months. The order of the is at page
Any witness have been examined?
yes, your lordship. 8 witnesses. None of us implicated me.
8 witness have been examined.
Yes, out of 13.
What is the contraband?
Page 49, minutes. Codeine phosphate 41 bottles. Nitiot 10 tablets, 200 NOS, 70 NOS, 9 NOS, total 279 NOS tablets. And there is this P1 plus capsule 4952 NOS. But all of these will be fine from Safiqul, who
41
is
bottles of codeine phosphate.
yes, your
From syrup.
codeine phosphate 41 bottles.
And any other thing? Any other thing? Any other article?
P1 plus capsule.
What capsule?
P1 plus capsule. It is there in page number 49. All of these were found
How
from
many capsules?
4952 knots.
What does that mean? What does that mean?
I'm sorry.
Knots.
For knots. Numbers.
How many 8 witnesses out of how many have been examined?
That's 13.
Okay, if you're not taking the plea of grounds of arrest, then I don't.
That also I'm taking. And the main accused has been released. The bail order is page 75.
No, I'm not going to all this parity and all, but if you are not taking the plea of grounds of arrest, then you are not entitled to bail.
I'm taking the grounds of parity as well. Section 50 no.
You cannot.
But the main accused from whose allegation from whose
You don't compare the cases with the cases which have granted bail just now. They're almost for one.
No, I'm not comparing. I am what this man say my submission. From the raid was conducted before Safiqul Hussain alias Bablu, from whose all this alleged substance has been found. He has been released on bail by the coordinate bench. Court number 3 minutes. Page 75, there is an order. The order is of date.
Then you are taking the plea of grounds of arrest also.
Yeah.
Which page?
Page 76, 75 is the order. The order is of 16/5/2020.
Grounds of arrest?
Yes. That is grounds.
All right.
Have me my notes on grounds of arrest. Your lordship is.
I have.
Your lordship on the other occasion. If your lordship.
So now I have another judgment.
Yeah, on Reddy, your lordship, that I have taken out that Reddy. In this case, Justice Pardiwala, it is a latest judgment to 23rd May and 2025. It doesn't apply. In this case, the habeas corpus was moved before the Honorable Supreme Court, in which they alleged that the ground of arrest was served, but it was not meaningful.
So Bhyan Kumar's case also PMLA, but this case relates to a PM offense under the PMLA Act. Bhyan Kumar.
I'm not on the PMLA. I'm on something completely different. Here, the court, Honorable Justice Pardiwala, in his the judgment when he authored, the division bench said that to Bhyan Kumar is a landmark judgment at page 15 minutes, para 15. I have the judgment with me. I'll just read for you. The path-breaking judgment of this case in the case of Bhyan Kumar versus so-and-so reported so-and serves a pivotal reference point in Indian jurisprudence regarding the rights of individual upon arrest. It goes on from page 15, para 15 to 16 and 17. It's an entire celebration of Bhyan Kumar. Subsequently, in the part when your lordship is there on para 36, on which it says that if the arrest is given, he must be told. Now, in that, they have only summarized the earlier judgment of Kishore Mehta versus State of Uttar Pradesh. Right now, Bihan Kumar still holds the field. Based on this, even the earlier.
No, but now you have just shown, I forgot, somebody has just shown another judgment of the Supreme Court, latest judgment, that it will have a retrospective effect. So this judgment will have a retrospective effect on Bihan Kumar judgment. So Bihan Kumar won't hold the field anymore.
No,
This
these-
judgment will hold a.
I am not on that. I hear the thing is that this judgment doesn't disagree with Bihan Kumar. Rather, it celebrates Bihan Kumar. It says that Bihan Kumar is one of the pivotal judgment. A.
It
B.
celebrates and then it also simplifies Bihan Kumar.
No, Manoj. May I respectfully disagree, Manoj. If that's something
Yes, it's
respectfully
okay, it's
disagree.
okay. You'll have to place your submission.
Ah.
Yes. It's okay.
So, Manoj, in that case, para 15 and 16, if you read the entire judgment, it
I have
has
read
to
the
be,
entire judgment.
it has to be read in cognizance. What happens? A habeas corpus is filed stating that meaningful and I'll just read, Manoj. If the part in which your lordship is there, if a person is arrested on a warrant, the ground of reason for the arrest is warrant itself.
Not on warrant.
I'm reading the letter part in which your lordship is on.
Yeah.
It's from my understanding. If he's arrested without warrant, he must be told why he was being arrested. If he's arrested for committing an offense, he must be told that he has committed the offense for which he would place on trial in order to inform that he has committed a certain offense. He must be told of the
So
facts.
very good. It's good for you. Come, give me the judgment. It will have a retrospective effect.
No,
It's
my
good
lord.
for you.
If these
I
judgments,
understand. You
even if I take
you
a plea, no, let me
You are
come.
celebrating that Bihan Kumar judgment.
It's
No,
a
I won't let
celebration
you
of a
come
Bihan
here.
government. The other part is,
No,
if
I
I
won't
take a
let you
plea,
come here.
if I take a plea that the grounds of arrest was not submitted, the burden is upon the prosecution to prove it. Now they will have to prove it that the ground of arrest was submitted. Here it's not about the
So
written and the
let
thought.
me hear them. Now I won't hear you. Yes, prosecution.
One more item is there. That's it. Then I.
Together, okay. All right.
But I'll also please allow me to also respond. Whatever
Yes.
you please allow me to respond.
Respond. Yes, you can respond.
Much obliged. I don't believe it.
You give me the judgment.
Yeah. This is on Reddy,
Yes. একেবাৰে শুনি পেলাই prosecution শুনি
Page 37.
কাৰণ দিনৰ পৰা ৰৈ আছে। You are referring to para 15.
Yeah, from para 15, 16, all the judgment has to be read in cognizance with what we know. These are all just the passing remark. I had no bearing.
All right.
Other high courts has also taken that.
You give me a judgment of other high court also.
I don't have result right now. I don't have, but I can bring that on the.
I won't pass the order tomorrow. You can place it tomorrow.
But this is also a case of on the same grounds.
Same ground, yes.
Same grounds of arrest.
So you are behind bars for how many days?
2 years, 3 months, 3 days, almost 2 years. 2 years, 5 days. And on same offense, my lord, on same ground, my lord, another co-accused has been granted by your lordship by an order dated 8 May 2025 in BA number 110, which is annexed here with Annexa 3, my lord. Operative portion, your lordship will find from 19 onwards.
Page 19 onwards.
Yes, ma'am.
All right. And then what is the contraband?
Contraband, your lordship, it is a case of opium, 3.5 kgs of opium.
And how many witnesses have been examined?
That is, I could not go through because LCR is,
I'll check.
so I am not on merit actually.
Only on grounds of arrest.
Only on grounds of
Which is the, have you annexed the notice, section 50 notice?
Yes. At your lordship will find Annexa 6 and 7 both.
All right.
At page 26 and 27 of this application. There is nothing reflected any grounds of arrest
All
in
right.
26 and 27.
Okay. হৈ গ'ল ন এইখিনি গোটেইখিনি? So PP, yes, you can place your submission for all the cases. এইখিনি হৈ গ'ল। মই গোটেইখিনি কেছৰ কাৰণে একেলগে submission লৈ PP বেলেগ এটা folder বনাই লওঁ। আজি ডেটটো আহি পেলাই না সেইখিনি আছে আছে মোৰ ওচৰত আছে আছে নেকি ঠিক আছে
Lordship, here in this case, Lordship, the main issue comes from the Article 22 one. And I think I need not to go and again read the entire
No,
part
no,
in the
no,
what does it
that,
say? It is no, now it is known to all that the Article 22 and what does it say? It says, Lordship, that immediately after his arrest, he should be informed. So till the day of, there are some other judgments which I have already on that
Yes,
relied,
yes.
Lordship, that the Constitution based answer 1966 AI, Lordship, wherein it is stated, Lordship, that he should be told, he must be told that regarding the ground of arrest also. So Lordship, till the day of, even though it is on field, Lordship, holding the field because it is a constitution based.
yes yes
And therefore, Lordship, in 310/23, the Honorable Judgment, Pankaj Bansal judgment came, Lordship, wherein it is stated, Lordship, in para, Lordship, it is stated, Lordship, that para 36, it is stated that he should be informed in writing. And prior to that, Lordship, there was no any scope, there is no anywhere written, in any judgment it is written that, Lordship, he has to be informed in writing. So thereafter, Lordship, R.K. Arora came. In R.K. Arora, Lordship, it is on 15/12/23. In para 23, it is stated, Lordship, that Pankaj Bansal judgment is prospective as it is henceforth. And in that judgment, Lordship, one line I would like to read, Lordship, one line only. That is para 23, the judgment that I have already given, Lordship. The last from R.K. Arora. So, hence, may I read that line was. Hence, non-furnishing of ground of arrest in writing till the date of pronouncement of judgment in Pankaj Bansal case could neither be held to be illegal nor the action of the concerned officer in not furnishing the same in writing could be faulted with. So, it is stated also that it is not faulted with, even though it is not given. But we have furnished. We have furnished one, even though we have furnished one Article 50 notice.
50 notice. Yes.
Nowadays it is 47, earlier Article 50 notice. Yes, that is in that only because of that, in that notice, it is not mentioned that ground of arrest is not mentioned. It cannot be denied. Because persons who from whose position, persons who from in such kind of NDPS, persons knows it very, very well that they are what they are doing. So immediately they are very much aware about the fact. So they, even though we are punishing them the we are punishing them the ground of arrest in 54 form. 54. So thereafter also, yes, after thereafter Prabir Purkast came. Yes, in Prabir Purkast case, there are some guidelines came that he has to be informed. He said ground of arrest is to be like in this way, region of arrest is to be this way. So there are some guidelines framed. But prior to that, till the date of pronouncement of judgment of Prabir Purkast, there was nowhere mentioned in what manner it has to be punished. Simply ground of arrest has to be written from the date from Pankaj Bansal. But prior to the arrest of Pankaj Bansal, it is the Honorable Appeals Court has stated that it is not required. Only submission is sufficient. So whatever it is stated, even what my learned friend has stated, that it has to be a burden shift upon us. That has to be that when it has come from the Bihan Kumar judgment. Not prior to that. In Pankaj Bansal, it is not stated anything. In R.K. Arora, it is not stated anywhere that we have whether we have stated them or not. We have stated because we need not to prove it because we have furnished him a copy itself. From 50, section 50 notice we have furnished, and itself its notice says that yes, I have furnished, that is the ground of arrest. That for such in cases we have been arrested. So, Lordship, till the day of Prabir Purkast, there was no such stringent rule, no such specific guidelines that he has to be a ground of arrest has to be in such and so. After Prabir Purkast, Bihan Kumar came. Bihan Kumar says something more than the Prabir Purkast, that he should know what language he has to be informed. So these are the procedure. Sometimes so one law is there, one one rule is there that he has to be informed. So subsequently, it has been developed into Pankaj Bansal. It has been developed to the writing. Thereafter, in a Prabir Purkast, it has been developed to some more region of the differentiating the ground of arrest, region of arrest. It has been differentiating. Thereafter, in Pankaj Bansal, it has come with some more development that he has to be informed in that what language he understand.
But you see, just now, I got a judgment from the Supreme Court recently passed that it will have retrospective effect.
But
Whether
that,
they
that
say-
I will come. That I will come. That in which case the retrospective effect will come. That or not also. That I will come to. I have also the apex court judgment also. Constitution based judgment also. So Lordship, in Bihan Kumar now the state Lordship, we have to furnish him written ground of arrest the language which he understand. Suppose in in Pankaj Bansal case, after Pankaj Bansal, we are giving them the section 50 notice. Section 50 notice that you have been arrested in social. Thereafter, because of the Prabir Purkasta game, that notice goes. And because of the Prabir Purkasta, some guidelines stated, mentioned, because of that not followed, as it is a retrospective effect. So, even though we have complied the Pankaj Bansal order, the bail may be granted because Prabir Purkasta not confirmed, not followed. Thereafter, Bihan Kumar came again. Now Prabir Purkasta were following, but now person will come. So I don't know English. I don't know English, but that is in English. So it will again it will go. So these are the procedure we have to we can say these are the procedure how it has to be developed. But the main thing is that ground of arrest has to be given or it has to be told as per the mandate of the constitution because so that he can avail one legal practitioner so that to defend him. This is why ground of arrest has to be informed. So Lordship, thereafter Lordship, we find that that Kasireddy came Lordship. It says Lordship that is not required at all. Even though we told him that why you have been arrested, the mandate of the Bihan Kumar is to be fulfilled. That is specifically mentioned in para 36. So in time to time it is changing. So if we go by the retrospective effect in each and every case that Darship has directly pointed out before some time, that then why not why only the Bihan Kumar husband we are going to follow? Why the Prabir Purkasta? Why not R.K. Arora? Why not Pankaj Bansal? Why not state of Maharashtra versus Sovaram? That constitution bans up to 1966 judgment. Why not those judgments? Only the Bihan Kumar. It is not that the Article 22(1) is not only for granting bail to them, only to give some protection, some protection so that they can avail some legal protection.
Granting bail.
Lordship.
Now that they are using that retrospective effect only for the bail purpose.
Lordship. So Lordship, even though I'm on the point Lordship that retrospective effect when Pankaj Bansal judgment is also the ratio has been taken from Pankaj Bansal Prabir Purkasta in Bihan Kumar case. When Pankaj Bansal's judgment is specifically said henceforth, so it has been ignored. It has been ignored. It has been ignored in that part has been ignored in the judgment Lordship. That part has been not looking whether it has the prospective or retrospective. Whether these judgments will go to the Pankaj Bansal or to the 1990 or 2000. So that part has not been decided. So Lordship, when one part is not decided, then we can say it is a para incurrum will follow, will come. So regarding that, Lordship, now it is Lordship. One constitution bench judgment is dear Lordship. Regarding that, Lordship. Rishabh Sethi. Pranay Sethi. In the case of Pranay Sethi Lordship, prior to that Lordship, Sandeep Kumar Bapna Lordship, on that day I have mentioned Lordship, Sandeep Kumar Bapna, and Sandeep Kumar Bapna is also discussed in Pranay Sethi. In Sandeep Kumar Bapna Lordship in para 19, Lordship will find Lordship. What does it say regarding a contradiction of judgment or by the same bench, same. Para 19 Lordship may kindly come. In Sandeep Kumar Bafna. It cannot be, Lordship got it. It cannot be overemphasized that the discipline demanded by a precedent of or a disqualification or diminution of a decision on the application of the per incuriam rule is of great importance, since without it, certainty of law, consistency of ruling, and comity of courts would become a costly casualty. A decision or judgment can be per incuriam any provision in a statute, rule, or regulation which was not brought to the notice of the court. A decision or judgment can also be per incuriam if it is not possible to reconcile its ratio with that of a previous pronouncement judgment of a co-equal or larger bench. So here in our case, Lordship, it is Lordship in when
Co-equal
Pankaj
bench.
Bansal has been stated, this is prospective. Now it cannot be retrospective, Lordship, which will cross the boundary of Pankaj Bansal also. Reconciliation for the previous judgments of a co-equal or larger bench, or if the decision of a high court is not in consonance with the views of this court, it must immediately be clarified that the per incuriam rule is strictly and correctly applicable to the ratio decidendi and not to the obiter dicta. It is often encountered that in high courts that two or more mutually irreconcilable decisions of a Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of per incuriam. So this is the judgment. Thereafter, Lordship will find this is two judges bench, Lordship. Thereafter, Lordship will find it in Pranay Sethi, Lordship case. National Insurance Company versus Pranay Sethi and others. This is a constitution bench, Lordship. This is of 2017. And it is still holding the field. Lordship will find here in para 16. Para 16, 17, 18, 19, up to 23, 23, Lordship. In every way, Lordship will find, Lordship, why I will read only one paragraph, Lordship. Para 16, Lordship. In state of Bihar versus Kalika Kuwait, an earlier decision may seem to be incorrect in to a bench of a coordinate jurisdiction considering the question later, on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter earlier, but it would not be a reason to say that the decision was rendered per incuriam and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of the coordinate jurisdiction. Thereafter, Lordship may kindly come to 17. The court has accepted the said principle of the basis of judgment on the court rendered the Union of India versus Gulferi Phillips in Private Limited. So it may be noted here that the Constitution bench in Madras Bar Association versus Union of India has already stated that the prior Constitution bench judgment in Union of India versus Madras Bar Association is a binding precedent. Be it clarified, the issues that were put to rest in the earliest Constitution bench judgment were treated as precedent by the later Constitution bench. So, Lordship, there are so many judgments. It is here. Sandeep Kumar Bafna is also discussed, Lordship, wherein it is stated, Lordship, that when there is two judgments pronounced by the same strength of judges, the earlier one will prevail. The next will not. Will be the per incuriam, Lordship. So, Lordship, here in our cases, Lordship, when the earlier order says, Lordship, when the earlier judgment says, Lordship, it will be prospective effect. Then the next Bihan Kumar judgment, only the Bihan Kumar judgments cannot say, Lordship, that it will go to the retrospective effect, to that effect also. Yes, that if that when one judgment has been pronounced, when judgment has been passed, it may have the subsequent effect, but it is not a retrospective effect. Even we can say, we can argue on that point that it has no, the entire judgment is per incuriam, because if we go by the judgments of this apex
But
court.
I'll just show you the judgment. There is two bench judgment, not first one Arun to Kochile, sir. First, lot to the first argument go to the beach. Adi, second half of the
Item 33.
reserve for order court is
33. 33.
33.
Lordship, I have heard that judgment while he was reading. Because here it is stated, Lordship, that when there is a when one judgment is not saying about the whether it is retrospective or prospective,
Yes, yes.
it is the normal course, Lordship, that everyone
It
will,
is
it will
there.
go retrospective. To that effect, Lordship, I will.
For that, we don't need a judgment actually.
Lordship, that is retrospective effect even in every case, Lordship. But when it is effect, when there is no contradiction of judgments, when there is no contradiction of judgments, but if it is contradicts come, when there is, that is why this kind of judgments come, the apex court judgment has come, constitution based judgments come, that here there is a contradiction came. Because of two views of two different ends, Lordship. Then this will come, Lordship. Otherwise, every judgments have the retrospective effect.
Yes.
And to that also effect, Lordship, I have submitted one more judgment, Lordship, that is regarding sub-silent errors. Why? When there is sub-silent, it will be under as a per inquiry, Lordship. Here, Lordship, the state of UP and under versus synthetic and chemicals.
Yes.
Lordship will find here it is para 42.
42, okay. Okay.
42, second, next page, Lordship. For last paragraph, 42 last paragraph.
8 does not do it. No, it was 42.
Last paragraph. Sales tax or purchase tax, Lordship, 42, next page, Lordship.
Yes, yes, yes.
Sales tax or purchase tax under entry 44 is levied on sale or purchase of a goods. It does not contemplate any distinction between luxury and necessity. Luxuries are separately taxable under entry 62, but that has nothing to do with entry 54, where what prompted this submission is not clear. Neither there was not any occasion, nor there is any constitutional inhibition or statutory restriction under legislative entry, nor does the taxing statute make any distinction between luxury and necessity for living tax. In any case, the bench did not examine it, nor did it base its conclusions on it. In absence of any discussion or any argument, the order was founded on a mistake of fact, and therefore it could not be held to be law declared. Here in our case, Lordship, though Pankaj Bansal's judgment was ratio has been taken, but that part has not been discussed. Even the Pankaj Bansal, the ratio is that para 36, Pankaj Bansal. Probably para 36, the ratio has been laid in para 36 in Pankaj Bansal. That has been discussed. Even it is stated, Lordship, that it is a suggested. In para 15, it is suggested. It has been mentioned in Bihan Kumar judgment. Even though in para 13, Bihan Kumar judgment, Lordship will find the last paragraph wherein it is stated in Bihan Kumar that Constitution does not say that written grounds of error has to be given. That, Lordship, I will like to.
No, I have found.
Para
I've seen
13.
that, yes, yes.
So when everything has been declared, so when ratio has been taken from Pankaj Bansal, but that part was not looking there. So that is why it is self-silent. The bench further was not apprised the earlier constitution Sugar Mill versus State of UP, which specifically dealt with the legislative competence of levying sales tax in respect of any industry which had been declared to be of public importance. Therefore, the conclusion of law by the Constitution bench that no sales or purchase tax could be levied on industrial alcohol with utmost respect fell in both of exception, namely rule of sub salientia and being in par inquirium to the binding authority of the precedents. So that part is sub salientia, we may say, because though it is binding effect, but that part regarding the retrospective effect, that part will not come, Lordship. That is why, Lordship, and that judgment will not come here. That that is retrospective when it is not said anything. It will retrospective. That will not come because in that case, Lordship, I think there is no any mention regarding the contradiction of two judgments, two views.
All right.
In these two cases, Lordship, I have submitted, Lordship. So apart regarding on the basis of this text, Lordship, I think, Lordship, my humble submission, Lordship, that they are not entitled for persons who have been arrested prior to the Pankaj Bansal's judgment. When R.K. Arora says, Pankaj Bansal says everything is prospective, the retrospective effect cannot go. So they are not entitled for bail.
My lord, I have relied one judgment of this honorable court on, in support of my case, which your lordship will find in paragraph 10, page number 4. In paragraph 10, page number 4. May I read out?
Yes, yes.
Reading of the aforesaid provision, it appears that while Article 21 protects the arrestee stroke detainee from being arrested without following the established procedures of law, under Article 22, subsection 1 provides twofold protections to an arrested person. Firstly, it is mandatory for the arresting authorities to inform the arrested person as soon as may be the grounds of his arrest and his right to bail, and secondly, to produce the arrested person before the jurisdictional magistrate within 24 hours of his arrest. Therefore, it is the fundamental right of an arrestee to be informed the grounds of his arrest and his right to consult and to be defended by a legal practitioner of his choice and to be produced before the nearest magistrate within 24 hours of his arrest. This right is guaranteed to an arrestee under the Constitution of India. If it is taken away from the arrestee, it would be depriving of his right to liberty, which being his precious fundamental right, such arrest would be total violation of fundamental right. Which your lordship,
I've read it, I've read it.
which your lordship, which is the binding precedent since 1996, my lord. So my learned PP argued that it is a prospective order, Bihan Kumar, that is not, cannot be deemed to be the right submission, right approach. It is this law is prevailing from since 1996, my lord.
All right. I'll pass the orders.
Or
Respond.
Hmm?
I have to respond.
Yes, yes. What?
in item 36.
There is another judgment of Justice Padiwala. On the confessional part, section para 53, page 28. It says that also in my case, I have been made accused because of the statement of a co-accused from whom substance was recovered. This honorable Justice Padiwala in this para 53.
No, this is not required. It's known to all.
That no place can be placed at the time of trial because that statement itself is inadmissible.
And go to it.
And the other thing is on R.K. Arora and in which learned PV, there is no contradictory view. R.K. Arora, this also was argued in.
I'll read it. I'll read it.
This was argued, just assist, let's allow us to assist. Because in Praveen Pugastya, this argument was argued before the Honorable
It's
Supreme.
okay, it's okay. You
It
don't
was-
have to explain me so much.
It was rejected by the Honorable Supreme.
Okay. Next matter, Mati.
May I please hear, Lordship? Lordship, in this case, appellant was convicted under section 4 of POCSO, and the Lordship, he was sentenced for a period of Lordship.
Attempt number 15, 1550.
15.
AB.
No, I mean, I cannot.
Lordship, this matter may be passed over for the time being.
Time being. Pass over for the day. Learned Counsel Miss
J. Ahmed.
J. Ahmed has prayed for adjournment. List the matter on. Do you have the CD? Postpone it. Equine. This matter is pending for what?
Lordship, next Friday.
Okay, Friday, Divya.
Item number 16 for orders.
I for bail.
Lordship,
You are convicted for how many years?
Lordship 10 years, and he is in custody for more than Lordship 2 years.
16,
Item number 16, bail. Conviction bail.
Lordship, they have,
Posco case.
state have
Posco.
filed objection, they have filed their objection, Lordship. And service also complete. Amicus Curiae was appointed in this case. So Lordship,
We will not hear amicus because appointed and amicus is not here. We will hear both sides. If both sides are ready.
Amicus Curiae is not present, Lordship.
Not required. Not required. Already appointed, not present, not required. We'll hear both the sides. You'll place a submission now? Posco conviction. Are you ready?
Ready.
I can take it up or no? I am very doubtful whether I can take it up. There is a notification also.
Yeah, notification is there, madam.
Hmm.
Notification is there. Nice.
May I please your lordship, I am appearing on behalf of Mr. U Chaudhary, who is legal counsel in this matter. So in this case, we have already taken steps for issuance of notice upon respondent number 2 through the registry, and the same has been handed over to APPP for forwarding to OC of demo.
As per official, my lord, service report awaiting, my lord.
Awaited.
My lord.
Service report on respondent number 2 is awaited. List the matter after 1 week. 1 week.
My lord.
আপনার কি আছে? দূৰৰ মানুহ হয়। বেল নেকি?
No, civil matter, you know. Civil appeal, first appeal. I don't know why this, the thing in the criminal branch is.
No, this is happening because of actually
No, your honor is
many
to,
cases and
lordship is to take up the civil matter first,
yes,
faster.
yes.
We should not wait for the civil.
I know. Civil
Lawyers should not be
civil
waited for the last.
not kept waiting.
Yes.
Civil people should not be kept waiting.
Yes. We are not hurried to get right from the.
I know. Like bail matters, unlike bail.
Each matter may be come,
Maybe the
12,
appellant-
13 matter is pending.
Maybe the appellant was in a hurry.
I don't
Maybe
know.
there was a submission from the appellant side, maybe.
I don't know, it's 2012, 13 matter is pending. There is 24 matters.
Appellant is not represented today. Learned Senior Advocate Mr. B. Dotto is present for the respondent number.
Always.
For the respondent. List this matter for hearing after vacation.
In the usual course, no. This
I
how
think
is,
the appellant was in a hurry, maybe.
no, how it could be? The boni suit.
Money suit is more important.
He say, my lord may
After
take it in
vacation,
the
okay.
camera proceeding, this suit, this matter. It is a love and affairs between this plaintiff and the defendant. In usual course, my lord.
After vacation.
Item 23.
Who will wait till now?
My
It's
lord.
already 4:30.
Up to 4:30, my lord.
বাকিবোৰ লেপটপত কৰি দিওঁ নেকি?
Only
এইটো last না?
PPs are here, man.
Only PPs. Always PPs are.
Always PPs are here.
PPs are waiting till the end.
My lord.
Last no. Parties are not represented, list the matter. 2 weeks নালাগে.
Full pending.
এইটো appeal হয় না? List-
Revision.
একেবাৰে silent দেই।
2 years conviction, my lord. Under section 354.
List this matter for hearing on appearance of any of the parties on the next date fixed. This matter will be decided on merits. We'll decide on merits. Not interested only. No.
Petitioners are there, perhaps.
They are there.
For some time, they are there.
Oh, they were.
Few minutes ago, they
Oh.
perhaps left.
ঠিক আছে নেক্সট টাইম এনেকে কৰি দিলে আহি যাব।